petition law community, private enforcement is often associated with antitrust. But state aid rules too can offer effective national remedies to competitors and other interested parties. It is therefore surprising that we do not see more of it. That's of course something we will look into today. A common thought is that state aid enforcement is mainly a prerogative of the European Commission, given its exclusive power to authorize compatible state aid, and that national courts play their role only at the margins of the system. On the contrary, national courts are central to state aid enforcement, as the Commission can only effectively exercise its powers if member states comply with the procedural rules laid down by the treaty, namely the notification and standstill obligation. The standstill obligation in particular has direct effect vis-à-vis member states, and national courts are the natural forum to remedy any breaches, as we will see, with remedies that are far more expedient and effective than the Commission's tools. For quite a long time, the Commission has been encouraging national courts to engage more actively in state aid private enforcement. First, by introducing mechanisms for cooperation and exchange of information in a first notice on the cooperation between national courts and the Commission in the state aid field from 1959. Later, the Commission notice on the enforcement of state aid law by national courts adopted in 2009, which provided more detailed and comprehensive guidance in light of the procedural and case law developments. On 23 of July 2021, the European Commission adopted a new notice on the enforcement of EU state aid rules by national courts. Despite these efforts, and as we will see today, the development of private enforcement is still underwhelming. That means that especially for more local measures, for which national courts are much better placed than the Commission to act, the state aid enforcement is probably suboptimal. As a consequence, less unlawful competition distortions are detected and tackled, which harms the competitiveness of the single market. Considering this problem, the objective of today's reality check conference is first, to collect detailed experience of how the state aid rules work in practice in national courts. Second, to identify the potential obstacles to the application of the state aid rules by national courts and claimants which prevent progress towards the objective of developing private enforcement of the state aid rules to its full potential and to improving the cooperation between the Commission and the national courts. Third, to identify good practices and draw lessons from past and current initiatives to maximize the use and impact of state aid and to simplify, to the extent possible, their understanding and application. This reality check output will serve as a basis for a new, more targeted enforcement study that DG Competition intends to launch in the next couple of years. Now let me proceed with giving you an overview of today's agenda. In the morning, we will have two stock-taking sessions. In the first, we will hear the result of the last recent study on the enforcement of state aid rules organized by the Commission, delivered in 2019, and then a very interesting presentation of an extensive academic study that is currently ongoing on the same subject. In the second stock-taking session, we will hear about a particularly successful training program which has been co-funded by the Commission, which we think achieved the difficult objective of creating a small community of state aid judges. We will then learn how, in the field of antitrust, a community of judges was actually born and grew into a formal association which contributed enormously to the development of private enforcement. So then later today we will also be joined by our new Deputy Director General for State Aid, Anthony Whelan, who will join us. After the lunch break, we will have three thematic panels. The first one about the advantages and disadvantages of private national claims in state aid matters, in particular as compared to complaints with the European Commission. The second will explore real-life issues arising in state aid damage claims with a focus on successful damage awards in France. Before moving on to the third panel, we will then have the privilege of hearing Executive Vice President Ribera remarks on state aid private enforcement. And then, after a short coffee break, we will have the third panel, which will take a more prospective look at what can be done to improve private enforcement, both from national and European angle. Importantly, of course, every one of the panels will be followed by a Q&A session. It's after all a reality check, so we also want to hear from your experience. We warmly welcome you to all take part in this discussion and share your views and experience. I would also ask you systematically for each of the panels, if you have questions, to first introduce yourself so that we get a little bit an idea of what your background and experience is. With that, I propose that we move on to the first session about the studies carried out on state aid private enforcement. It's really my pleasure to have and to present two very distinguished speakers who have very long experience in state aid control. The last study carried out for the Commission was delivered in 2019 by a consortium composed of Spark Legal Network, the European University Institute, ECORIS, and CaseLex, with the support of a network of national legal experts. Today, we have one of the coordinators of the study, Francesco Salerno, who will tell us more about its results. Francesco is a recognized expert in state aid, managing partner of the Brussels office of Gianni Origoni law firm with a rich and prolific academic background. It will then be the turn of Jacques de Rennes, who will tell us about the preliminary results of studies carrying out independently of the Commission with the University of Liège and the specialized review Concurrence in a very large part of the EU. Jacques is the managing partner of the Brussels office of Shepherd Mullen law firm and professor of state aid law at the University of Liège. Interestingly, Jacques also coordinated the very first study which was carried out for the Commission in 2007 to 2009 on the topic, and can therefore give us a unique perspective on the long-term developments of state aid private enforcement so far. So with that, I would ask Mr. Salerno to take the floor. Thank you.
Thank you to the organizers, and especially congratulations already for a very well-organized conference. This is the first time that I get an email saying, if you have a problem, here's the number to call. That I think it's a sign of a really well-organized, well-thought-through conference. So I'm privileged to stand here and to share with you the findings of the study that we did. It was rightly remembered, I was one of the many that worked on this endeavor. I'm happy to speak for them all. It was certainly a teamwork. I could have not done this alone. But it seems to be that I'm the memory of that study, so I'm happy to share memories and to look forward a little bit. So in 2019, we were younger, a little bit younger, but certainly younger, and springy. This was before COVID. And certainly when we went into this study, we had a lot of energy, and we said we want to go out there. The previous study is now a little bit old, and it was 2006. Let's see what is going on, and let's be honest, what's wrong in the world of state aid and the national courts, because it was, and seems it still is, underwhelming. So that was a little bit the spirit with which we started this study. The findings, some of them are informative, and I think they continue to be informative. Be happy to share those. Some of them already were reality check territory, and I'll be happy to share those as well with you to start feeding into this reality check process. So let's start with the informative. We found that private enforcement was gaining ground. The cases had tripled since 2007. Part of this was due to what was then the crisis, in everybody's mind, the financial crisis. Little did we know that a year later we would have had another crisis. But anyway, this I think we felt invigorated by the fact that number of cases had risen. Another interesting finding was that the type of measures out there at the time defied a categorization. It's a testament to the fantasy of politicians and public officials, the type of measures they can concoct to influence market outcomes. So it's not by coincidence we have case law that says we need to look at the effects, not at the form of measures. I think that is still true today. Plaintiffs came from a variety of walks of life. Only 30-something% was your typical plaintiff, the competitor. There was a significant part of plaintiffs which belonged to the category of beneficiaries. And that, I think, already speaks to the reality check type of thinking. Because it's all well and good to tell a business person when his aid is clawed back that he has no legitimate expectations when his measure was not notified and approved, but your average business person would feel, let's say, at the least let down, if not tricked. And what he will ask his lawyer is to go to court. Go to court to get his or her money back. So that already, I think, it's something that we have to bear in mind, that the reality is that a part of these actions come from beneficiaries. But the real reality check is that what we found then, and seems we continue to find, is that plaintiffs did not get what they were seeking from private actions. 66% of the cases ended up in, let's say, an unsuccessful result. And that was reality hitting us straight in the face. So the thinking process started, why is that? Now, the good news is that in some cases, this was actually the correct result. And I go back to the slide about beneficiaries being plaintiffs. The beneficiary sues to get money back. In many cases, the correct result, dura lex, sed lex, is that he is not entitled. In many cases can be a circumvention of a recovery order, for example. So that was part of it. But can all of those 66% be like that? The reality, again, is that some of those judgments, let's be honest, it's a thing of the past, no offense, were wrong, for a misapplication of state aid or no application of state aid. And why was that? So at the time, I think the thinking was a high evidentiary burden. And I think this language often alluded to a well-known culprit, the MEOP test. You can't expect all judges in Europe to have studied finance. So sometimes when faced with this type of arguments, it was simply too difficult. More generally, we all know state aid is a living organism. It's made of several components, all of them in motion, so it's a difficult concept to apply. But perhaps another element of reality check, again based on the findings of the study, is that in the vast majority of cases, when you go to court, to a national court on a state aid matter, what you are facing is the state, the mighty of the state, in its several incarnations. And believe me, as a plaintiff lawyer, that inspires a certain fear. Now, I don't want to put feelings in judges' hearts or minds, but let's think for a moment. Also, if you're a national judge, on one side of your courtroom, you have a private claimant seeking monetary awards. On the other side, you have a government, a parliament, a law that has been passed, often thousands of beneficiaries that risk all of that being put in danger. Do you want to undermine all of that for one claim or even a group of claims? I think, at least on the emotional level, it's something we should all reckon with to understand why state aid enforcement at the national level remains underwhelming. And so believe me, when David went into battle, he had full confidence in God that there was happy ending, and so the Bible says. But when the plaintiff goes to court, I think that type of confidence sometimes can be misplaced. So that, I think, explains the reality that we found back then. Let me now quickly feed into that reality check process two more recent examples. With two disclaimers, the examples come from one jurisdiction, so it's a limited sample, of course, and I was involved in one of the two cases. So let me start with the one I was not involved. Arriva Italia went to the Court of Justice, so it's somewhat well known. And that to me is your typical playbook case, let's say a success story. So a competitor goes to court against an aid granted to another competitor. It is an ad hoc measure. The competitor is a well-resourced competitor. It's the Italian subsidiary of Deutsche Bahn. Competitor manages to get the Italian competition authority involved. That authority has the power to issue opinions on a state aid nature, yes or no, of a measure. So that opinion comes out, it's state aid. Case goes to court. In first instance, the competitor loses, goes to the highest court, Council of State, referral. And the referral comes out in the sense that yes, it is a state aid case. National Court, Council of State takes that judgment and, let's say, implements it. So the measure of aid is annulled. Success story, I think to a great degree, yes. Now the other story. Small energy trader challenges a scheme for production of renewables. Goes to court, Council of State makes a reference to the Court of Justice, which hands down a ruling, innovative on many, many aspects, but what's more important, it is a ruling that requires new activity at the national level. It requires economic analysis, assessment of that analysis, perhaps appointing an expert. National judge awards victory to the plaintiff, but totally sidesteps the state aid plea. The result, a referral, apologies for nothing. That judgment of the Court of Justice remained in Luxembourg. The judge was not in a position to, let's say, implement it. So, years have passed. We are older. Are we wiser? Well, perhaps. At least we can reflect on what it takes to make a claim successful. The first piece of advice is go for ad hoc measures for the David and Goliath situation. Avoid schemes. They are much more difficult to overturn. There is only one Van de Colère. Make friends. Don't go alone. In Italy, there is the National Competition Authority. We found in the study that other jurisdictions have other authorities which are in charge of doing preliminary reviews or similar type of activities. It is a good idea. And the third lesson, if I may, is that the reality is what it is, but is also, it can be what we make it to be. And by that I mean that with a small doses of humility, we can make it better. Because, at least I speak for myself, Brussels, I regard it as the capital of the empire of state aid. And from here, we look at national courts as people that we need to evangelize. But it has to be a two-way process, and it is already starting to be like that. When that little sentence in a judgment, on a referral, it is for the national judge to do this and that, one should understand that that has to square with national legal systems. Yes, the principle of effectiveness needs to make sure that everything works, but that's not real. That's not the reality. The reality is that if a judge has to undertake new and complex activities, he will not do it. So, one little lesson: to make it real, keep it simple. Thank you.
Thank you very much. Very insightful, very good refresher of the previous study, but at the same time already drawing very important lessons from it. I'll immediately pass the floor to Jacques.
Thank you, Koen. Thank you very much to DigiCom to set up this meeting. We should have that every year, to have a gathering and make the point on the situation. In view of time, I will try to focus my presentation on 12 unresolved issues. I don't have the response to each of it. I have some ideas. I'm pleading those cases sometime. Academically, I have mixed feelings and a bit of introduction before, but that will be the main part of my topic. I will wrap up a bit, indeed, where we are going from for the studies and what were the issues and the takeaways we can have from that now, concretely. And I will just remind you, because you should know that, the main principles and the best reading for each national judges or each lawyer, and simplified presentation of typology of action, which I present to my student, which is quite telling. In one slide, you can teach state aid law, 90% of it for national courts, in one slide. And then the unresolved new issues. So here on the left, you have everything a national judge or a lawyer, not specialized necessarily in EU law, should know and should have in mind. And basically, the last three, I mean, notion of aid notice, recovery notice, enforcement notice. With that, you have it all. It is a bit out of date for some of them, notion of aid, of course. The Commission cannot update that every year when the court is changing its mind. But it is, the three notices are the real reading that you should propose, submit to national judges and lawyers pleading before national judges who do not know about state aid. And the rest, you know about it, and you see that the studies that we have conducted, the first one in 2000, in fact 2000, with Association Européenne des Avocats conference, and then we had the studies of 2006, and then the Congress in Cyprus, and then the recovery notice came, and for the notice, we updated that, and then we did the book already in 2010. All that is still valid, and as Francesco mentioned, we have reached now a level of sophistication in database, of knowledge, of sharing information, which is quite unmatchable and useful for all of us. Now, the takeaways of all that on the right, there are a lot of cases, more tripled, and I've seen that it was already tripled in 2006. So we are getting a quite good level, and state aid is more important at the Court of Justice than antitrust, as you know. Right? You have many more state aid cases before the court than antitrust cases. So we are well served from that, but it's still a bit messy sometimes. Private and public. I would prefer to say it's national enforcement and not private enforcement, because there are a lot of enforcement by the state as well, which give rise to a lot of issues, which is interesting and useful for the national enforcement. So we should not only limit or focus on the claims by private parties, but also the claims by the state. We should claim some time to apply state aid. Now we have cases in most member states. Some of the member states have even no public enforcement or some not private enforcement. There is a few, 2 or 3 now, and it has been mentioned in the studies. It's quite largely shared for the time being. But we have very much fragmented procedures. Nationally, you know, we are dependent on national procedure, and that's a mess. It doesn't work really well with different traditions. administrative, civil, commercial, etc. Of course, there is different avenue to apply state aid law, but as you know, state aid law is still not harmonized. We have all the case law which harmonize the principle, but the way to implement it is not harmonized, and it's the source of many cases, many issues. Now, we do not have an harmonized prevention mechanism. I always refer to this Cyprus example. In Cyprus, I think it's still the case, I mentioned that in my book in 2010, and Mr. Lykourgos, who is the judge at the Court of Justice, was the author of that chapter for that 2010 book. In Cyprus, there is a state aid commissioner. That person can stop the member of the parliament at 5 o'clock in the morning when they push on the button, I vote that. You know that after midnight, the government is putting some illegal laws, not only state aid, and then put that, and let's vote that. The state aid commissioner in Cyprus should stop it. He can't stop it. He said, no, there is a problem, let's suspend that. Why we don't have that everywhere? Why? Why the Commission doesn't push member states to be prudent on that type? Because most of the problem are coming from the member states. Of course, the state aid is a state from the member state, and from the legislature, the government, because they are manipulated by the government, the legislature. That's the problem. And we should take the problem at the source, not when the disaster happened. And that we have to do a lot of efforts on that. It's not the problem of judges for that, for the time being, but it's a problem for the Commission and the member state to talk about that and to be serious about it. Now, we are not serious about it for one thing, and that's, I turn to Koen, unfortunately, and the Commission, but I'm still very disappointed by the attitude of the Commission vis-à-vis state aid. When you have a cartel, we have a press release, you have a 700 billion fine collectively to cartelists. The Commission issue a press release, and there is a bottom footnote which says, and even a section in the press release which says, and don't forget to sue them in court. Get damages, because I cannot grant you damages, I impose fine. Okay, that's perfect, no problem. Now, you have a negative decision in state aid. 100 million, billion, etc., to be recovered. A state aid violated the law. At last, the Commission saw it, managed it to get a recovery, and then there is a decision to recover the state aid, which is unlawful and incompatible. And there is a press release. And the press release doesn't say that. The press release says, well, there is a violation, the state, and then I did my job, etc. But why the press release doesn't say, and sue the member state? Why not? Why the cartelists are privileged to be treated like that? The member states are privileged in a way. Because they are the member state. That's the response. But that's my main problem in state aid. The law is not the same for all. And we know the story. We are in the EU, and why we had to wait for 40 years to have a procedure regulation in state aid, and only 3 years to have an implementing regulation for Regulation 1762. Because it's a member state. So that's my main problem in state aid. And this is reflected to what Francesco said. And then you are against the scheme before a national judge who is the conseiller d'etat, who is a member of a court, and he had to put companies in bankruptcy or to apply the law, which would be a disaster in employment because of the state. But he didn't do that to do it. Why? Because he's a state. So that's the main problem. Psychological, attitude, incentive. The rest is the law, but it's maybe less important. So there is a low incentive effect as well to go against member state beneficiaries because of the difficulties. Legal costs, I've been told that in Germany, legal costs, it's according to the value of the case, etc. And then you have to pay the cost if you lose, a bit like in the UK. Then you don't sue because it's too risky, it's too difficult, and you are not confident in what would be the risk. There is always a risk in a legal suit. But that's a problem, too harmonized. And then most of the cases are when the people doesn't want to pay a tax or as recovery indeed, or have a dispute in public procurement. It's still the same type of statistics. Francesco saw the statistic the same as mine in 2006. You go to court to apply state aid law for another reason than state aid, in fact. And it's a tool, sometimes good tool, sometimes bad tool. And we have some national legislation, but it's not harmonized. In some member states, they decide, oh, I will apply that rate. I will refer to the Commission rate by legislation. Fine, I will do that and that. There is a Dutch law on recovery. There is no recovery law everywhere. Why not? Why not? Why the Commission is not there to harmonize a bit? I know why, because they are not supported by member states, but they should try to push it a bit. So that's my main problem. So, Koen mentioned the study, academic study. There is indeed a book that we are trying to finalize. It's a pre-book launch. So tonight we will discuss that a bit with you in my office with Nicole Robbins at Oxford. We are inviting most of you, the people we know that they were here, and other people can see me at the end and they will come. So there is a book indeed. This is indeed the table of contents. You can see a bit the detail. There is, in fact, 3 chapters in that book which will be released in June. Hopefully, we will finalize. We have done the 3/4 of it. Chapter 1 would be a treaty of state aid, 100 pages, 100 page, on all a national code should know from the courts, case law. Everything will be there. Then chapter 2 will be a digest of chapter 3. Chapter 3 is national experience, with chapter for 15 selected member states, in which we will create hyperlinks in the book. It will be an e-book, and you can click on the hyperlinks, which will be the name of a national case, and go to the case summary and the full text of the judgment, which will be in the database. So when we read the book electronically, you can access everything in Europe about state aid, in principle. Not exhaustive, of course, but so that's the intention of the book, and then have in chapter 2 the digest of that thematically. So that's, we can discuss a bit later tonight, but that's the objective, to contribute to the evolution of the knowledge and sharing the knowledge of state aid in the bubble. So another point I wanted to refer quickly is what the national courts and national lawyers, because the courts, the judges are held by the lawyers who might not be specialized in state aid in competition. If you know all that, you're okay. I've selected 25 cases. You know all of them, I hope so. Costa, Steinicke, SFEI, Boussac. They're all there. Striker West is not only competitors, also any third party affected who can complain. Boiron, Transalpine, Scott 1, Scott 3, Lucchini, Klosner-Holz, Nelson and Tunes. You can recognize Bosen. Bosen is a case, point 48, which says that the national member states do not need judges necessary. The member states are obliged to go to recover without a judgment. Without a judgment. They do not know that, all member states. So there is an efficiency in the case law which is not applied sufficiently enough. So all that you know, I'll skip it a bit. And here I summarized mainly SFEI case, which told us nearly everything for the national courts in reflection of what the Commission can do, distinct and complementary roles. That I'm not sure that all lawyers, certainly not, and all national judges called to apply state aid law knows about that. I was happy to plead this SFEI case 30 years ago before the Court of Justice, and I realized that indeed it was so diverse in terms of principle in that case. It's still very much valid. You know all that, and I will refer to that in the discussion, notably in the categories and typology of action which can be done before a national court. So with this slide, indeed, which I use with my student for many years, and which is not fantastic, not very nice, but still okay. You start by the member state. The member state did it wrong for some time, for something. he did not notify or implement without authorization, or he abuses the aid, etc. And there is the issue. The member state could, in certain situations, or should in certain situations, enforce recovery, enforce the decision of the Commission, of course, which is a title, or go to court to get the support of the court to enforce the law and make it better and repair the wrongdoing. And it goes against the beneficiary. That's quite logic, and it happens. Now, I go to the competitor in Brown on the right. Competitor and affected third party. As I said, Streko's case, he said that not only competitors can claim, also any third party affected by a tax which is an aid, for instance. There may not be competitor. So that third party can sue the state. First, it's more logic. The state was the source of the wrongdoing, and they can sue it without necessarily any legal basis in law, in national law. They don't need a legal basis in national law. The legal basis is a treaty, directly. They don't need anything else in most of the cases, except some statutory limitation, nature of some aid, damages, etc. But basically, everything is in the treaty, which are called the autonomous action. Then they sue the member state that they can ask everything: stopping, suspend, recovery, damages, cease and desist, etc., etc. So the litany is endless. And that's the start of the disaster, the dispute between us, of course. Everything can happen in that. But then the competitor, that's SFEI case. I was, unfortunately, the first one in 1993 when we go to the Commercial Court in Paris, and then in 95 before the Court of Justice, and the case in 96, yes. You can, when you are the affected third party, the competitor, sue the beneficiary directly. Then the court refused to say that there is an obligation under EU law, but there may be an obligation under national law based on liability law. If it is illegal to behave on the market with the support of something illegal in national law, it should be the same in state aid. That's the reasoning of the principle of equivalence of the Court of Justice. Then you can sue the beneficiary with that basis, the same legal basis, 1083, with recovery, damages, suspension, interim relief, cease and desist order, preventing payment, everything. That's a bit more difficult because it's a bit creative, and it doesn't work. There is a few cases which has been launched on that, and we do not know good successful cases because notion of aid is indeed sometimes the obstacles, but it is difficult. And then we have the last arrow, which the Commission doesn't like, but still doesn't understand what I said, the green one. The green one can sue the state. Of course, it cannot circumvent. And of course, it cannot get the money, the illegal money that he got in the unlawful aid or the unlawful incompatible aid. Of course, he should recover that. But in certain situations, not in all situations, in some situations, notably in the Borotra cases, which I mentioned many times, in 96, the member state could have caused a damage to the beneficiary, which has nothing to do with recovery, because recovery is not the damage, of course, it's not sanction. You have to recover. But the fact that you received that state aid, that there was a wrongdoing by the state, may have created in certain situations a damage which should be repaid by the state vis-à-vis the beneficiary. And of course, the amount of the damage has nothing to do with the state aid, has nothing to do with the causal link of the state aid, has nothing to do with the amount of the state aid. The example I quote always is Borotra cases, the Minister of Sport in France, who lied to the Parliament in France. And they said to the Parliament, I created a scheme for the shoes and industry, textile industry in France, reduction of social security increased, and that's fine. The Commission is agree with that, no problem. Sign here with the Préfet, there is a decree and then the law which confirms it's okay, and the Parliament voted at night. And the Minister said, no problem, Brussels is okay, no problem. It was a lie. It was a lie, a political lie. Because 2 weeks after that lie at the Parliament, the Commission, it was not the era of Internet, published on DOJ the formal investigation procedure against France. It was, of course, totally illegal. Of course, the Commission was suing France. And of course, the Commission won the case before the Court of Justice. And of course, the member state had to recover the aid from the scheme. 2,000 poor manufacturers who wanted to delocalize their production to Morocco and Tunisia. And they did not do it because the state said, keep the job here, I will give you a gift, illegal gift. But he didn't tell them. It was a lie. And then what happened? I was the first lawyer invited to sue the state. I went to Grenoble Administrative Court, and I sued the state. I lost my case because my causal link was not good, but others won. Why they won? Because they show I have a damage, my loss, I missed the profits I could have got from my delocalization to Morocco, and I changed my mind. I decided, the board of directors, I decided to delocalize, and I changed my mind because of the lie of the member state, of the state aid. So the state aid was unlawfully incompatible, should have been recovered, and give rise to some damages against the state, which has nothing to do with the nature of the state aid. But you see, if the beneficiaries were more, and if the state felt that they could be sued by the beneficiaries in some instances, that would be a good incentive. And I'm disappointed that in the enforcement notice, the Commission did not mention that, tried to say that all those cases are circumvention of the law, which is not the case. There is circumvention, and there are issues. I'm not talking about that. But I talk about example, model, and the fact the beneficiaries could be the incentive for the member state to respect the law. Finish for that. Now, let's go to the 12 unresolved issues in 5 minutes, 10 minutes. First, public policy plea. We still do not have a good case. We have Van Skydel, we have EcoSwiss. Competition law is public policy, fine. But what is the real obligation of the national judge? You judges here, if you have a case where the lawyers do not raise state aid, can you raise state aid yourself? You should, I think. But in what manner? How not to circumvent and how not to disturb the object, the subject matter of the case. There are rules about public policy pleas. It's a bit delicate. But this is something that the Commission should develop a bit and push national judges to identify, because you will know more than the lawyers pleading before you, judges here today. So you can, there was an issue. What do you think about that? And then you reopen your hearing, etc., and then you have another case. Why not? So I think it's important, notably for the aid qualification and identification of unlawful aid. Second point, I mentioned already autonomous EU legal basis. We should promote those cases based directly on the treaty. You do not need any legal basis, and awful discussion about the legal basis. You remember that the rebellion of the German judge in 2006 until 2011, the Bundesgerichtshof, I think, stopped that rebellion. Many Court of Appeal or first instance judges in Germany contested Costa Enel and SFEI case. They said 108.3 cannot be applied by a judge. What a big mistake in Germany. And the Commission was even about to sue Germany for wrongdoing by your judges. Finally, it was fixed by the Bundesgerichtshof in 2011. But it is an issue. We should clarify that. National procedure I mentioned, there is a lack of harmonization, and we discussed that with damages probably. We should have a damages state aid directive. We don't have it because of what? Member states. Why we have it in antitrust? Because of member states wanted to sue cartelists, didn't want to be sued themselves. Okay? That's the situation, but we should have it. Secondary effect of aid, I will skip it. It's a problem of notion of aid. Lack of transparency, indeed. the aid is known too late. In phase 1 decision, nobody knows about the aid. You discover suddenly, oh, the Commission accepted, authorized an aid. I didn't know it was notified either, of course. Notification is not transparent. So there is a lack of transparency because of whom? Member States. Why we are not more transparent in state aid, like in mergers? And that's a deficit in the application of state aid law. The E8 de minimis register, the time, etc., works not really easily. I've been told that the Croatian, they have a good E8 de minimis register, but even not Germany, because in Germany it's difficult to get the data together. It's possible in Croatia, not in Germany. The Commission should push a bit that, but there is no 1st January this obligation, of course, in this E8 register, which is a good step. And there is, I mentioned, no stated person in each member state. Why we don't have a Mr. or Madam State Aid in each member state? Not a guy from the Ministry of Finance, a guy from the cabinet who is defending the state, not the law. A person defending the law at national level who can be, a bit like the State Aid Commissioner, the Mr. Madam State Aid, who would be the person, the go-to person for the Commission and for the public, the citizen, and the claimant to discuss a bit and to attract attention. Why we should not have that? Commission should suggest that. Then cooperation, amicus curiae. Yeah, sorry, I missed this, yes. There have been 29 amicus curiae, 21 decisions, 21 cases. 20 observations to third countries, because my friend Tim Maxen-Rucher is going over the road on arbitration, and 30 opinions. It's not enough. In 20 years, well, since 10 years, it's nothing. Why? We don't have resources. It's only the legal service who is doing that. There are 15 people in the team. But why we don't have an amicus curiae every month? Why the Commission is not pushing a bit more that and going to show what would be the law, some mistakes sometimes, to the national judges? Why do they wait for the disaster? They don't go for first instance, they don't go for court of appeal, they go for Supreme Court when it's too late. I have the same, when I asked DG Comp to convince the legal service to go before my judge who is in difficulty, there is a big problem. They say, no, it's too early, let it go, and then too late. Then 5 years down the road, when there is an appeal, when there is a reverse, when there is a Supreme Court, it's too late. It's a disaster. So I think we should change the approach and push a bit more on that on behalf of the Commission. Of course, it's difficult for a judge. Administration is not a judge, and it's not a circumvention of the premier ruling, but it's still very much appreciated. But it should, you see the statistics, 50 occurrences all over the place for 15 years in Europe. It's nothing, it's not enough. So, last slide, more important. Alors, this is cases which are pending now. I will not mention too much, but I have other cases which are not mentioned. But these cases, SAS cases, the C399 and 44295, have cases from Sweden and Denmark in April and July. They are before the Court of Justice now, and they ask a question which are summary in a nutshell. What happened when the unlawful aid, the unlawful character of an aid, comes only late because the authorization, the decision of approval of the Commission has been finally annulled by the Court of Justice, the General Court in first instance, and with retroactive effect there is an impact on the fact that it's regarded to have been never existed, and then you have suddenly an unlawful aid. Whilst the aid had been totally legally notified, totally legally implemented, because we waited for the approval of the Commission, and then there was a recourse on the substance, and the decision was annulled. The notification is still valid, not affected by that, so it was not a violation of that. And there was a fictitious effect thanks to the fact that the authorization is no longer valid. by retroactive effect. But at the time, it was valid. So do we have to recover in that case? That's the question, in fact, of the SAS case, because nothing wrong. In the past, nothing was wrong. No distortion of competition, no advantage, nothing. 4 or 5 years for the old procedure, totally the member state did not violate anything, full respect of the law. And then finally, the Commission made a mistake, which has nothing to do with the substance sometimes, procedural mistakes, etc. And then there is an annulment. What would happen in that case? And these are COVID cases. If you have to wait for the definitive character of the decision, those cases are still not definitive after 5, 7 years. So you don't grant the aid, and the company is bankrupt. You don't think it's a bit disproportionate? So there is a question to the court: is it still valid to say that the recovery is mandatory in that situation? And the SFAI case again said recovery obligation, yes, unless there are exceptional circumstances. The court didn't say what was the circumstances, and this is an example to be judged. So I draw attention to that. Go to the Court of Justice site. There is a full text of the question of the judges with full reasoning, very interesting. So to be followed. Arbitral tribunal and national court. My point is not to talk about state investment, because then Tim Maxian, who is not there, will stand up, but commercial arbitration. Just in a nutshell, recovery notice, Article 267, Article 29 regulation, they don't apply formally to the arbitrators, arbitral tribunals. They don't apply. But public policy, the arbitral tribunal should apply ECOSUIS, the law, etc., when the law is applicable to the arbitration, etc., through the member state EU law. Yes, they can say there is an aid. I think, yes. But is it good to say that this arbitral tribunal, who cannot be helped, who cannot recourse to the help to the Court of Justice, would be empowered to order the recovery of state aid in an arbitration decision? Is it good in law, that? So we push national court to say, be careful, go to the court if you have a problem, you have a doubt, etc., you have the assistance of the commission, etc. The commission is assisting those arbitration tribunals, but it is a connivence. It is not provided with procedure. The tribunal can say no. It is not in the regulation. The regulation applies to the commission only and the commission situation with the national courts, not arbitral tribunals. So why arbitral tribunal would have the same powers as a national court, why they don't have the same tools? My point is to ask you, don't use the Article 4.3, the TEU does not apply to tribunal. They have no obligation of sincere cooperation with EU law. So there is a problem there which is not solved and not addressed. Alors, second last, damages, I will skip it because we will discuss that in the session. There is a lot to do, and member states are at the brakes on that. Unlawful interest. Again, it's a question in those SAS cases, but in some member states, when you have to recover unlawful aid, you apply unlawful interest. If you are in the situation of self, you do not ask for the principal amount, but you ask for unlawful interest. What level of interest? And I just wanted to draw attention to the discrepancy between the level applied in a negative decision by the Commission. This is the reference rate which is applied by the Commission, which is quite low, 2, 3, 4%, etc. So 100 base points on the EBOR, etc. And there is a reference rate taken by the Commission and updated, which is quite low, according to the market rate sometimes. But the Commission is applying that, and it's clear. And some member states, like the Dutch law, like the French case law, refer to that by legislation, so to speak, and that will be the interest rate. But what about other member states where there is no law, etc., and no clarification, because St. Pagar, the case St. Pagar of the Court of Justice, said that the rate of unlawfulness rate applied by the national court should be the rate of market rate, the rate that you should get a loan on the market, which has nothing to do with the commission market rate, commission reference rate. So my point is that it's better to have a negative decision of the commission. Huh? It costs less than unlawful aid before a national court. That's not good. It cannot be true. So we have a problem, discrepancy, and the court was probably ignoring that point, but when they said in St. Pagar it should be the rate of the market rate, etc., they didn't give a good service because they contradict the practice, which is good, of the Commission on the reference rate. We have a problem there. So I have clients who tell me I would prefer to have a negative decision of the Commission instead of paying my rate before the national court. So that's a nonsense. There is 12 only, so 11. Yeah, aid qualification and aid amount. There is still a good, I will not have detail on that, there is still a big problem about for national court to decide aid qualification, fine, there is a loan, there is an injection of capital, etc. But what is exactly the amount to recover? Because the amount of the aid is not necessarily the nominal amount of that aid. A loan can be the differential of the rates, market rate or not of the loan. That could be the level of the amount of the advantage in certain situations. In other situations, it should be the nominal amount. And that we need guidance from the court, we need guidance from the Commission on that. It is not well explained, and there are tricky things where they are the source of issues before national courts. And then St. Pagar to Boson. I mentioned that St. Pagar created this rule that the GBER, the General Block Exemption Regulation, in that case, the national administration should not have necessarily the support of a judge to go against the beneficiary to get the money back. And Boson case, which is always missed, extended that case outside GBER. It's a general principle that the first obligation of the member state is to recover itself by law, by EU law, terms the unlawful aid directly without a judge being involved. And second point, point 49, there is a slight discrepancy between the de minimis situation and the GBER situation. It looks like that when you have a de minimis which is a bit above 300,000, you pay back everything. It's not a de minimis. And not in GBER. In GBER, you are a bit above GBER. You will recover what is not GBER covered, which is not correct with the de minimis situation. And that's a case which should be before national court, and that we have not a solution by the Court of Justice or the Commission. Voilà. Thank you very much for your attention. This is all my issues.
Thanks very much, Jacques. 12 tasks, it seems Herculean. I'm not sure we'll be able to tackle all of them today, but I think it certainly gives some food for thought. So I open the floor for discussion. If you want to add some more points to Jacques' list, of course, very happy to leave. Yeah. If you could just introduce yourself before you ask the question or comment.
Hello, good morning. My name is Miguel Caramelo. I'm a partner at Andersen. I have a comment and a question for Jacques. I totally agree with you that beneficiaries should sue member states when they suffer damage. But what about public companies who are owned and controlled by the state itself? And they often have to follow the policies or the wishes of politicians, and therefore their decisions are not based on, business decisions, but the wishes of those politicians. They suffer losses, they accumulated debt, and later the state decide to give some aid to them, often not notified. And then these companies will never, if this aid is declared illegal, will never sue the states because it's their owner. So don't you think that in a way member states should be sanctioned sanction when they are when they grant illegal state aid?
Yeah, in that case, of course, the public undertaking should have the minimum autonomy to manage themselves according to the law. If it's not the case, it's an issue, of course, but I understand the problem. I understand that they might not even have the internal legal power to decide to go to court because they are controlled by the state itself. That could be an obstacle. But in that case, the managers of that company should have the responsibility to share the issue publicly, share the issue with the Commission informally. It's not impossible. And the Commission can backfire a bit against the member state informally and have a solution like that. But I see the point. It is a full conflict of interest and vicious circle. It can happen. These are some cases I had in the past on imputability. I mean, it's not impossible to show to the Commission that some of those companies have a minimum autonomous which can allow them to show that certain act of the state is not imputable to them sometime. Huh? That's possible as well when there is still a certain autonomy on the ground for the board of directors, etc. But indeed, if it's fully controlled, and that's reality. Yeah?
I can contribute to that. Let me contribute to that again on a learning from antitrust. No, in antitrust there are compliance problems, and it is possible to have compliance also for state aid. It is possible that those type of companies have self-assessment of what they do built in their own bylaws. And indeed, it is a practice I can share. It's a best practice. And I think it's very advisable, precisely, for the benefit of everybody, of the company itself, but also of the state, to avoid these embarrassing situations. So there are ways to prevent and avoid that problem arises, with all the complications that are inherent in what we are discussing. But there are solutions out there.
Reason why it's important to prevent this type of situation, to have independent external persons who can review that. That should be the role of court of auditors, etc. But it doesn't work really well. And that's State Aid Commissioner in Cyprus. If we had that type of people in each member state, that would be the go-to person and to solve the problem, because it would be like an ombudsman, etc., an incentive for the state to evolve.
Thank you. Further questions, comments? Yeah.
Right. My name is Antonio Creus. I'm a lawyer involved in certain issues like these ones. And, it's been extraordinary for the Commission to take this opportunity. And thank you for the wonderful presentations. I wanted to just touch upon a couple of points. One is that when I see Jacques mention the number of amicus curiae and all that, he's such a nice person. He didn't mention that about 60% of those ones relate only to, in reality, one matter or two matters, yes. Micula and the Spanish renewables energy cases. So that makes it a state of 60. It comes to about 20 for a number of years, so hardly many. I think it is something very important. The other thing, it's this wonderful tour d'horizon that we have done shows that there's a number of issues. Good, that's important. But to me, it's more important which one we pick first to start moving the things. And I think amicus curiae, it's probably one that would help if expands a little bit and widens a little bit, because it makes difficult for a national court after an amicus curiae to do certain things. And that to me is important. Also, all amicus curiae end up saying, look, if you have doubts, there is the Court of Justice. And most of the cases then go to the Court of Justice. That to me is already an improvement on this sort of complex horizon that has the state aid situation right now, because it makes difficult life. And also taking priorities. Jack also mentioned the fact that beneficiaries can claim damages. Well, if we follow this path, at this stage, we're weakening probably the situation. I don't contradict you that there may be cases, but that's one of the defense that has anyone who receives a state aid. Oh, well, I'm going to have damages afterwards somehow. So I think to me it's essential to start prioritizing issues, and some of them put in the front, some others as back burners. Thank you very much.
Apologies, Jack. I just wanted to react to that because to share experience. I had one, not of any of the two lines, different, and I can only share frustration. I can tell you, my experience has been very bad. If of the 12, if I had to vote, I certainly don't vote for amicus curiae because let me share that. It is one thing for the Commission to appear in court, but then you have to appear also before the Court of Justice, because the effect of the amicus curiae really is to convince a judge, which has the option, to make a referral. But then the matter goes to the Court of Justice, and the Court of Justice is a different game, because the Commission has to appear, of course has to appear, but then there's the member state in all of its power, and sometimes the member states, and the game is completely different. So if you really want to make it real, my personal little experience, let's not start with amicus curiae. There are the 11 options that we have. Perhaps, let's rank them different. But that's my experience. Jacques, please.
Yeah, I like the idea of amicus curiae because we should do what we do in antitrust. In antitrust, it's not that successful either. Huh? But amicus curiae, there is an obstacle for the Commission because the team of Leo is not extendable endless. They don't have the time. It's normal. They can't. They should be hundreds, and Leo would be glad to have 100 people, but he don't have them. So it's impossible to manage that for them. So they have to prioritize. Okay, even if we imagine that they can go and search any case and go to case, etc., and ask the file from the judge and submit amicus curiae in writing, it's quite delicate situation. Huh? Sometimes they have to side with one party or not. Sometimes they are called by one party. It's not well perceived. And I've seen some amicus curiae which is published. Sometimes it's a cause of law which is quite stringent and quite difficult for the judge to digest, huh? Because frankly, it says to the judge, this is my opinion, but if you do not follow it, it's your risk, and I have the solution. So it's a bit delicate to manipulate, but I think it's one part of the game, and we should convince judges to accept that assistance, which is quite odd for them because it's an administrative animal, which is not a judge, which is coming there, interference. Huh? It's a bit difficult, but it's part of it. But I think the most important is psychological. It's to change the view about state aid, and first to understand that state aid is competition law, and stop all those English who say competition and state aid. No, state aid is part of competition law. State aid is the third pillar of competition law. And the Commission in its statement, they say state aid and competition, and we have the feeling that state aid is a bit different. Of course, state aid is linked to internal market, linked to all that. It's not like antitrust, etc. But it's competition law. And the people still do not feel that well. And there is a problem of image of state aid. And that we have to change that. And that would be the first priority, I think, in terms of communication.
And I maybe just add to one reflection. I mean, of course, amicus curiae is one element which is brought forward, but in the end, I mean, you are practicing lawyers, you bring suggestions to the court. There are other tools, like the possibility to ask for information, to have the consultation process. Are these not complementary? So I don't know if you have any...
Yes, of course. I mean, it's a bit difficult sometimes because it's changed now. In 2000, I was the first one to ask request amicus curiae of information from the Brussels court. They sent a letter which never reached the Commission in a few hundred meters. It can be quite strange. But indeed, request for information, opinion, all that is quite flexible. You have some time limits on that. It's quite quick. Yes, I mean, only to get data to get explanation of procedure, because of course before a court, the first defense will say, oh, there is a complaint before the commission, stop it, don't do anything, or if we notify, we wait for, all that is stupid and unlawful, of course, but it works for a judge, huh? And we should not wait, of course, but they wait. And there, indeed, if the commission would be coming and say, of course, you should not wait, because I have other objectives and it's difficult, but you should decide. Only that, said by the commission, which only reflect the reality in the procedure, would help. So indeed, the tools are in a different level of gravity, and indeed, it's not often used enough, probably. Huh?
My comment goes, I fully share what Jacques said. My comment is towards, this sense of community, to have a two-way discussion, because somebody goes to court and says, oh, there is a complaint and DG Comp is investigating. So, and of course, if the judge doesn't have that type of, let's say, education, the effect is what Jacques described. They will perhaps automatically assume that there's something wrong with the measure, just because somebody has sent an email and got an RS number they can quote. If there's that sense of community and training, the judge will know that this is only a first step. In a way, anybody can do it. Even a citizen can do that. So, I think there, this type of creating a sense of community, understanding better what is the procedure, I think will help a lot.
Thank you. Maybe one last question, because otherwise I risk already running late from the first panel onwards.
Thank you, Antonia. I had a question. First of all, thank you for your contribution, Jacques, with regards to the public policy remark. Because as I understood, you said that would warrant ex officio application. But I was wondering, with regards to the procedural rule of reason test and under effectiveness, also if you look at the Kloosternoor-Holst judgment, that ex officio would already be possible of state aid rules. So I was just wondering what would your perspective of categorizing these state aid rules as public policy. Also, you refer to EcoSwiss, etc. But I would be of the opinion, especially with regard to 107, that this is quite a different nature if you look at 101, for example. But that, yeah, I was just curious of your thoughts.
No, when I say public policy, I think ex officio by the national judge, it could cover 1071 and 1083. 1083 is in tandem with 1071. So the role to identify an age should lie with the national court first, who should be the first judge, the lawyers, of course, and the member state is own first judge. If there is a disaster and that they created an aid which had not been identified, the pleaders, I think it should be the role of the judge to identify the issue ex officio. And I think I claim that if it doesn't do it, it's a violation of the law. There are limitations because the judge cannot, I think, I'm not specialist in civil procedure, but cannot modify and disturb the subject matter of the case. But of course, he should get the view of the parties and raise it to the parties so the principle of contradictory is fully respected. But if you follow that, you add an issue which is important to the case and the parties will discuss. I don't see the problem. So if a question is ex officio by the judge, yes, I mean, we should have that. And we should explain to the judges that it is their role to raise it. But it's not only competition law, it's also maybe in tax, maybe in social security, everywhere.
Yeah, I think my comment then would be that I think that's already a possibility under effectiveness, but we can discuss that also in the willing time after.
Principle of effectiveness is a legal basis for that as well, probably. But my point is Costa NL, and direct effect and primacy is that. Everything is there. That's it.
Okay, then with that, I would like to thank again Jacques and Francesca for the very insightful comments. And with that, I think we move on to the second panel and we'll hear more about SUNAJUST.
Thank you.
I'm pleased to introduce the second panel of today, which talks about the experiences in training programs and also judges run initiatives. So I have the pleasure to welcome today the whole team of Synergists. They will introduce themselves, but let me just say that they are really, how could I say this, bring the gospel about state aid to the different judges in a lot of member states. So they participate in a training program which is called Synergist, co-funded by the Commission. So I have the pleasure to introduce Professor Caroline Butz, Professor Wout de Kock, and Seppe Maas, who are part of the Brussels Competition Policy Center. So thanks a lot. They will start with explaining their experience on Synergist. And then I also have the pleasure to welcome Adam Scott. It's really a big task to introduce him because he's one of the most experienced judges in state aid, I think. So he's, in fact, to start with the start, he was one of the founding specialist judges of what became later the UK Competition Appeal Tribunal. And his particularity is that he's the only one who has several qualifications. So he's not only an engineer, he's an economist with a doctorate in psychology. So I think we will see it from every angle. So we are really pleased to welcome him. Currently, he's director of the studies at this tribunal. But apart from that, he also has a very special qualification that he's an Anglican clergyman for already 50 years. So I mean, this will really be, we are really honored to welcome him today. He will talk about the experience he had as a judge, and also the particular, how could I say this, the particular experience of the, as member of the Association of European Competition Law Judges, because giving the gospel is not only about training judges, it's also about creating a network. And I think this is really something very, very important. So we'll have the pleasure to hear their experiences. So thanks a lot.
Yes. Good morning, everyone. Many thanks for the kind invitation. And we are indeed very happy to share a few experiences from Synergist. We will share a bit the project and the setup, but then go into also a survey that we've conducted among national judges, and then also some lessons learned from our experiences. So indeed, so it's the team, mainly the three of us, that have developed and had the pleasure to engage also with the unit on enforcement on developing the Synergist trainings. And this has been in the context of indeed our Brussels Center for Competition Policy, which is an interdisciplinary center bringing together basically expertise, not only on state aid, but also more broadly on competition and industrial policy matters. Here we have listed just a few projects, as Sonagist is a very important one for us, but we've engaged with many different partners across the fields. To go into Sonagist more specifically, so what we've done, we've tried to develop a number of trainings. They entail basic workshops, but also more advanced workshops with exercises and more case methods, and also a number of conferences. So we've developed also a bit of materials to support that and to help support the judges in their role as EU state aid judges. At the moment, we are looking forward to the workshop in Salzburg. So these are the locations and the moments that we've already had events, and so there is still a number of them to come in the next year. In terms of participants, maybe we thought it would be interesting to see the participant profile, but also how many participants we've had from the different member states. So in total, at the moment, we have about 335 participants across the different workshops as well as conferences. You can see that the large majority of them are judges, but that there is also a big proportion of apprentice judges, but also different court staff and prosecutors. In terms of member states, there's also a bit of a spread with big representations from Romania and Greece, but also across the other member states. But you can see that there is also a bit of member states that are still, let's say, missing or not so much represented. In the Sonagist project, we also try to help stimulate or create this community among the judges. And so we do this by trying to create a bit of a network, but also by disseminating and sharing experiences. And in that sense, we've had a number of articles. I think all of them are also here today. So we've had Mercedes, who speaks later the afternoon, who shared a bit of experiences, not only in the events, but also in an article for the European State Aid Law Quarterly. We also have Zulema, who is here in the audience there, who shared their experience. And we, of course, had an article also about the cooperation tools. And interestingly, yesterday we had our editorial board meeting of the European State Aid Law Quarterly, and there we always look also at the top of the articles in terms of interest. So we can see basically behind the scenes how many articles get how many clicks from visitors to the website. And so yesterday we looked at this top 3. And although we may not see as much private enforcement maybe in practice than we would hope, we do see a lot of interest for the topic in Estelle, because on the first place was indeed the article by the colleagues here today. So that being said, we hope this can also still stimulate and help to create a bit of additional community feeling and the sharing of experiences, which can obviously be very informal, but can sometimes also go through articles and dissemination. And this being said, I think it is time to turn to the survey results, a survey we conducted among national judges last year, and for that I hand over to Seb.
Voilà, many thanks. And indeed, as Caroline mentioned, we've trained around, or by now, let's say around 350 judges. And fortunately, we were able to put quite some of them to work already and have been able to gather their insights regarding a few number of topics. In the survey that I will discuss with you today, we will tackle the responses of the judges. It were around 150 participants who participated in the study. And there we will now take a look at what they responded and what their main, let's say, barriers were when enforcing state aid law in practice before their competent national courts. And here we see that the most common remedies, the most often used remedies that they see or they imposed in their relevant national courts are, and it follows a bit what Francesco said this morning, are recovery of unlawful state aid, but also actions for damages and an action for annulments. Voila. But indeed, as Francesco mentioned this morning, maybe state aid or private enforcement is not yet at the level where we want it to be at. And we've asked the judges to provide their opinions on the reasoning behind. So why don't we see as much cases before their national courts as we would have hoped for? And there we see, interestingly enough, that one of the main reasons provided is a lack of state aid knowledge, a general lack of state aid knowledge coming from both private actors, like beneficiaries, like competitors, Maybe they don't know fully what can be done, what can be retrieved before a national court. But later on, we'll also see that it also applies to national courts themselves. They are not expert state aid judges most of the time, and so it comes with a number of issues. Also, a perceived limited national role and potential remedies here too. Once again, I refer to the panel of this morning where they said, well, Brussels is the beating heart of state aid. Maybe beneficiaries and national courts have the feeling, what can I do in my member state to, let's say, solve a certain issue in relation to state aid law? What can I do, and are the potential remedies worth it for me to bring this case before the courts? Most important for today, of course, is the private enforcement issues, and there we see that member states and members of the judiciary who participate in our survey mainly say, well, interpretation of the GBER, because we all know that the GBER is responsible for around, I think in 2024, it was 88% of new measures. And there we see that GBER measures often end up in front of national courts to be interpreted, and it's not always easy. And the reasoning behind that is a bit twofold. So on the one hand, you have inherently stemming from a GBER measure, a national court will have to decide, well, is this state aid in the first place? And there we see it's not always easy. For example, is there an economic advantage? Is the measure selective? Is it imputable to the state, etc.? We know the criteria, but how do we apply them in practice? And so that's where we try to help, to support the national judges a little bit. And the lack of state aid knowledge, both in the population, let's say, of the member states, so the firms in the member state, as well as in the judiciary itself, that is the most pressing need or the most pressing topic identified in our survey. Maybe public enforcement, I'll go over it very briefly, but there we see that the length of proceedings and the interaction with proceedings at the Commission itself or at the EU courts is seen as a big barrier, as a point to take into account, as a point of attention. And then, of course, most important to us, to the SUNAJust project, we've also checked how exactly or what format do the judges, do the participants prefer. And there we see very clearly people like to have an event in person, which takes minimum a full day. So they like to dive very much deeply into the topic that we provide them with, and they love it being in person. And of course, it will also help that it's in pretty nice cities, so they like to travel. But the fact that it's in person is a very big benefit for them, because during the coffee breaks, for example, they get to mingle, they get to talk to each other. And mingling and talking to each other, as Bernadette said, is a very important part of a training itself, because all judges said, well, we want the trainings to be closed to members of the judiciary only, but we are very much in favor of opening up the events to judges of all member states. So not specifically to one member state, we wouldn't like it. We like it to be open to colleagues of different member states. And now in what follows, Wout will guide you through the 3 most important takeaways from all our training sessions.
All right, so indeed, as mentioned by my 2 esteemed colleagues, we traveled to dozens of locations, dozens of very nice cities all over Europe. Just pour la petite histoire, on my birthday, my wife gave me a t-shirt with SUNAJust on tour with all the cities and all the dates where we traveled, because she always said, like, you're always away, so here is a t-shirt. So we spoke to hundreds of judges, training them in EU state law, and we spoke to these judges. So what do these dozens of workshops with hundreds of judges teach us and teach you as state aid community? Well, I will briefly discuss 3 lessons, but first of all, I want to emphasize that most of all, we should remain positive, because often people have the tendency to focus on the negative things. Well, I want to start with a positive lesson. The vast majority of the participating judges in these events were very enthusiastic about learning. They really love to learn about state aid law. They thought, well, this is so interesting. Why didn't I have this at law school? Because I had the great honor to have a class with Jacques here in Liège. But for example, at other universities in Belgium, they don't teach EU state aid law. They teach EU competition policy, but a course on state aid law yeah, you don't see that at many universities. So we should remain positive. That's the most important lesson. But immediately I will become negative, and I will focus on 3 negative lessons. But I put them in brackets because negative, like overall, the story is positive. And yeah, 3 negative lessons. You will recognize many of these lessons. Like the first panel already tackled the complexity of state aid law. I will focus on the second lesson. It's a Solomon reflex. Bernadette mentioned the word gospel. I think Francesco already referred to David versus Goliath. I will now refer to another biblical reference, like the Solomon judgment, of course. It feels like we're here in church a bit, the state aid church. And then last but not least, I will focus on the practical side of state aid cases, often forgotten. So first, complexity of EU state aid law. We should not underestimate that the principle of national procedural autonomy, which means that national courts enforce state aid law in accordance with national law, leads also to the fact that many judges enforce EU state aid law. Because who determines which court can apply state aid law? Well, national law. And for example, in Belgium, I'm Belgium, and I studied in my PhD, I tried to study it in my PhD, all the judgments of the Belgian courts on state aid law. Well, I can tell you, not only the lower instance courts, commercial court, court of first instance, civil court, name it, applied state aid law, but also the constitutional court. The Belgian constitutional court enforced state aid law. And this leads, of course, to a fragmentation of state aid knowledge, leading to the conclusion that it's not easy to these judges. Like, many of these judges apply state aid law only once in their career. So how can you expect them to apply, for example, the notions of undertaking or state aid, things we discuss every year at all these events we know in depth and in length? Like, how can you... So overall, the question I asked myself after speaking with hundreds of these judges is like, what can we realistically expect from national courts? I know this is not a specific advice I give to the Commission or to the courts, but it's more a reflection. More importantly even is the Solomon reflex of the judges. Like, these judges, they were very enthusiastic about applying state aid law. And they said, like, we really love EU law. Maybe the judges were a bit biased because they enrolled in this program co-financed by the European Commission. So they are very open. Yes, Costa NL, we know Costa NL, primacy of EU law. Yes, we know Van Gint and Loos. Yes, we know the milestone judgments. But if we apply state aid law, there we see that there is a problem. And what is this problem? Basically, on the one hand, you have national judges who have a tendency to protect the weaker party, and they want to end up with a balanced judgment where they apply the law, but they also have empathy for the parties involved. So that's what I call the sort of Solomon reflex. They look for a wise judgment. But this, unfortunately, does not always match with the state aid logic. Let me explain that. In the state aid law, we all know this because this is an experienced audience. It is well-established case law that the beneficiary of state aid, even unlawful state aid, is supposed to know that the aid it receives is unlawful state aid. Well-established case law of the Court of Justice. However, for many of the participating judges, this did not feel right, because who violates the standstill obligation? Who violates Article 108, paragraph 3 TFU? The state. And the state is ordering the money back, even though the state violated the law. And for many of the participating judges, they told me, like, look, this doesn't feel right. Like, even there were some cases, there were some cases where the state told the beneficiary, oh, everything is all right, don't worry, I am the state, I follow the law. And the judges felt like this doesn't feel right. So the main message I want to give here is, yes, I know the case law of the Court of Justice. Undertakings are supposed to know that a measure constitutes unlawful state aid. However, yeah, this does not feel right. And this is something I think we as state aid community should take with us. Because we are supposed to be the experts, we know this. But these national judges, they deal with all sorts of other cases. They want to seek a balanced judgment. So that's what I call the Solomon reflex. We should take that into account. Yeah, I put also a nice painting of by Peter Paul Rubens. I always promote Peter Paul Rubens because I'm from the city of Antwerp, and you can all visit the place where Rubens was buried, like in the church. They just reopened the church after renovation, so please all come to Antwerp and visit the church. Anyways, last but not least, do not forget the practical side of the state aid cases. Jacques already referred to the case where a letter was lost. If I spoke to many of the participating judges, and they told me, oh, amicus curiae, interesting, but where can I find the commission? Even the Belgian judges, although I know there are, I think, at least 2 cases from Belgium where they did find the commission colleagues here in the room, but it's not always that easy. Again, please realize that these national judges, they deal with so many cases. For them, in their 30, 40 years of practicing law, a stated case is maybe one of the thousands of cases. So never forget that. And then last but not least, also, the broader context of the national legal system I will skip, but EU state law seems far away. And that, adding on that, we should also remember that today there's a huge pressure on judges in all sorts of delicate cases. State aid is, of course, also a very delicate thing. It's about the state giving money to someone. This can be rather controversial. Imagine you being the judge, ordering the recovery of aid to a factory that went bankrupt and leading to thousands of jobs lost. It's not always that easy, definitely in the times we are living now. We see many parts of the world rule of law crisis. And that, last but not least, sometimes there are also long delays in judicial proceedings, and this, of course, does not always match with the expectations set by the Commission, recovery within 4 months or even faster. And, for example, to give one case in Belgium, there's a case by sale of land by a city in the north of Belgium to an undertaking. Well, first, the case started in 2016. Last year, I think, or it was this year even, the Supreme Court, the Cour de Cassation, or the Hof van Cassatie, quashed again a judgment, and the case is still pending. And in a month, we're 2026, so the case is already pending for 10 years. So that's the practical side of the case, and I think that was it. So thank you very much.
Life is interesting when you're running 10 minutes behind and standing between you and lunch. And when your slides don't appear. There we are.
Oh, there you go.
So, do I have a clicker?
Yes.
Thank you. Why start with extracts from my passport in the 1950s? Well, you've been given the answer already. It's about the gospel. The Gospel of Mark starts with the introduction of the kingdom. And my slides start with the introduction of the Treaty of Rome. I was 10 years old when I landed at the Hook of Holland on New Year's Eve in 1957, en route to West Germany with my parents. I was in Germany on New Year's Day. I was, I think, asleep when the common market came into existence. And I'm sorry to tell you that at that stage, I hadn't actually read the state aid laws that it introduced nearly 7 decades ago. And then on the 15th of January, I came to Brussels and saw the atomium. And I think it's worth thinking about the context in which we're talking. Europe matters to me. Europe matters first because I have no medals for France and Germany fighting each other. I was a child of a soldier in Germany, and later I was an artillery officer through much of the Cold War. And one of my heroes was Konrad Adenauer, one of the people who lay behind what we are trying to enforce. I won't go into a lot of detail, but this is just to remind you that it grew. So, what are we about? I'm from the Competition Appeal Tribunal, and you'll be glad to know that the Commission is allowed to apply to intervene in our proceedings as an amicus when we're dealing with state aid, or as we call it, subsidy matters. We aligned our competition law with that of the EU in 1998. But of course, we didn't need separate state aid law because that was looked after by the Commission. Christopher Bellamy returned from the EU Court of First Instance, as it then was, to prepare for the new tribunal. We started a new tribunal, and I was one of the founding judges, as you heard. Regulation 1 of 2003 was coming, and Christopher wanted to found an association because he wanted a college of judges. We've already heard about the Damages Directive, which helped trying to harmonize procedural law in relation to damages. Brexit, as you know, meant that we've left the EU, but we haven't gone very far because part of the Trading Cooperation Agreement is that we have a similar law in the UK, and we have taken over from the Commission as being determining legitimacy. So, what's the association about? His vision was for cooperation between national judges, EU judges, and the Commission. Annual meetings with topics and national judgment updates, and I haven't got a T-shirt. But there's the list. I must pass it over to my wife. Then there are annual meetings. We're having ours in Brussels the next 2 days with DG Comp staff here, and also ad hoc meetings. And we support judicial training. And we have this project to collect judgments. Incidentally, you don't need to copy the slides because we can make the slides available to you. So what are we looking for in collegial judges? Well, first, we want the coherent interpretation of the law, understanding the notions that we're applying. That, I have to tell you, is pretty fundamental to the application of state aid law. If judges don't have an appreciation of the notions, we are all in trouble. We're also in trouble if we don't have consistent application of the law, and that means being informed about how the law is being applied, both in Luxembourg and in national courts. There are other things that we look for in collegial judges, which I won't go into in detail, until I come to this. If we don't have good procedures well managed, we are all in trouble. And that is part of the problem I think we have in some national legal setups. We also need courageous judges, judges who are prepared to stand up for the law and to the state. And that's, I recognize, difficult. So making private enforcement of competition law effective, we have worked as judges very closely with DG Comp on the practicalities, on law and on guidance, on the Damages Directive, on quantification, on passing on, and on confidentiality. We've worked on handling multiple parallel claims. We have our annual updates. We've had virtual meetings when a lot of judges have been covering the same decision. And we have the project to share judgments online. You may say, we wouldn't be here if this didn't matter. And the answer is yes. But there are, as you've heard, problems. And what are the problems? Well, you've heard a lot of them already. Lack of training. Do they realize that help is available. And that's quite a question. Do they realize that you can ask DG Comp? You can ask your national competition authority. They may not know how to answer the question, but in some cases, they will. And if you get a view, either from the National Competition Authority or from the Commission, if you're going to go against it in your judgment, do explain why you think you're doing that, and check whether you're actually going against a judgment elsewhere. Competition law judges quite often don't actually handle state aid cases. We in the CAT are fortunate that we do both now. And how do we reach relevant judges and help them to understand, and as I say, have the courage to apply it? So lessons: understand effectiveness. Have the powers and understand the duties as a national court. Get help and be ready to refer a novel issue to the Court of Justice. Adjust procedural rules. We're reviewing our rules at the moment. And practice to aid effectiveness. Disclosure can be enormously important because sometimes the claimant really doesn't understand, because of lack of transparency, what's been going on. And that sometimes means handling confidentiality, and there's guidance on competition law. And look too at the guidance on quantification and passing on, because that is a help across from one to the other. So, making judgments available. We haven't covered state aid law at the moment. We've got the project. It's just competition law at the moment. You can upload in a national language. We provide keywords, and that enables it to be searchable in any EU language. It's called UKJUD, and it has a website. So, how do we help each other to improve national procedural law and practice? This meeting. What's been happening? What is effective? What's ineffective? What impedes effective enforcement? How can we help each other as we need to appreciate what works procedurally? How procedural rules can help effectiveness? How to manage state aid cases? And relevant association judges should help enable this alongside DG Comp. Now, I've managed to get to 10 to 12, 1 rather. And if you want to know what I think, read my chapter. But if I might be allowed to anticipate a question, can I, Bernadette, talk for a moment about the cases that we've had in the UK? Because I think there are some interesting things to observe. So far, since Brexit, there have been 8 cases. 4 have resulted in judgments, and in no case was a claimant successful, compared to 66%. But actually, they're very interesting questions because they help people to understand the process and the boundaries in state aid. The current 4 cases are interesting in one sense for what they're seeking. The first is a lottery case against the Gambling Commission, who regulate, accusing them of an illegal subsidy to the national lottery. And they ask for declarations, quashing of the decision, and of course recovery and costs. The next case is of Bristol Airport, which is near Wales, accusing the Welsh government of subsidising the Cardiff Airport. They want a declaration, they want it quashed, they want recovery, and they want costs. The next case takes you to a small community. We've had a case about Manchester. This is a case about a place called Bishop Auckland, brought by an individual and some other claimants. And it's about regeneration and how do you allocate regeneration money. Again, declaration, recovery, a mandate to force people to be transparent about what on the earth they think they're doing. They want damages, costs, and there's a quirk here in that we can award damages in Scotland, but the government of England and Wales tried to make it difficult for you to get damages in England and Wales, notwithstanding their treaty obligations. But leaving that on one side. And then the last one is quite interesting because it is brought jointly in state aid law and in competition law. And it asks for 8 different declarations. They want not only declarations as to the substance, they want declarations as to the procedure. And I think that is a rather interesting development on which I should probably end.
Thanks a lot to all of you for these very interesting insights. Indeed, it's about training, but it's also about spreading knowledge, about keeping these databases of judgments, which is quite interesting. And I think maybe we should reflect on that when we launch the study, how to take stock of these needs. And also the networking, I think, is very interesting. But now it's time for some questions. Yes, please, can you start by introducing yourself?
A microphone will be provided, just 1 second.
Yeah.
Thank you. Thank you for presentation so far. And my question, sorry. Yes, my name is Daiga Lagzinga. I'm from Latvia. Currently, I'm working as a lawyer consultant, but I have I've worked in national authority for many years, and I have experience also of working for European Commission. So I like experience as a judge. But my question is related with points mentioned by several speakers. You are advocating judges to consult with national competent state aid authorities, European Commission, but we do have 2 cases in Latvia already decided by European Court with preliminary ruling, which contradicts the court decided differently or interpreted differently compared to national authority and European Commission. So we do have 2 examples already, similar, that the court overturned what the Commission or national authority is telling national judges. And in Latvia, we are having very strong power of the national competition, not stated authority, which is within Ministry of Finance. And actually, their competence is more strict than, or their interpretation is more strict than even European Commission. That leads that national judges, just by consulting national authorities, go to the wrong direction. When you will be doing the next study, I would advise to look broader in this perspective and not push so much on national authorities, maybe to see what really is within member states, what are the powers, and how easy or difficult is to even get opinion from the European Commission. For example, in Latvia, it's very difficult to reach the European Commission because first it's blocked by national authority. Then you need to persuade them to go to the European Commission for the question, okay, With the judges, it's different. They just ask based on procedural regulation. And I'm presenting these examples because I was part on 2019 study from Latvia, and I presented these examples, and these were also analyzed within the study. Thank you for your remarks, if any, but these are recent decisions. One of them is Dobeles Hess, and another is Tode case. They are very controversial if we look from the national perspective. You have seen that from EU perspective, from the court. I know them from the national and for the implications what it has on national legal system and to judges. I will not go into details. Maybe later we can discuss with those who are interested. Thank you.
Yes, I don't know if anyone of the panel wants to react to that. Or, yeah.
All right, so a couple of reflections. First, to the clash between EU law and national law, of national perspective. As an EU lawyer, someone who's focused on EU law, the answer is quite clear. Already in the 60s, we had 1964, the Costa Enel case, supremacy of EU law. So the starting point should be, if EU law states it like this, you should, as a national court or national authority, follow the EU law perspective. That's, of course, the theory. In practice, it's, of course, often more difficult, definitely with national authorities and national courts who are really focused on national law, national practices. I just want to pick in on the focus on the one thing, like, of course, there's the procedure regulation in Article 29, which allows national courts to ask for an opinion from the Commission. What about national authorities? Can they ask the Commission outside the Article 108.3 TFEU procedure for an opinion? I think in the context of SUNAJust, the first conference, we invited at the time Ben Smulders, who at the time was not a judge at the Court of Justice, but was working here in Brussels at the European Commission. And the same question was asked, and he's argued that on the basis of Article 4.3 TEU, the principle of sincere cooperation, also national authorities with facing a problem like this can consult with the Commission in an informal way or asking for an opinion like, hey, what do you think? So there is, of course, the procedure regarding new state aid, but he argued, well, we have a duty to cooperate. So this might help national authorities faced with problems where they see, look, another national authority is going against EU law. Just a couple of reflections on that, but I understand, I completely agree, often from the national perspective. Yeah, it's EU, that's what I meant also in my presentation. We as EU state aid community always focus on the case law, and we know all the cases and we know the theory, but from a practicing lawyer or policymaker in the member states, it's not always that easy. I don't know whether other people here in the panel want to react on that.
I think that just as we have the problem of judges who don't come across state aid trying to do these cases, the same is true of a national competition authority. And it's worthwhile, if the national competition authority is going to be asked, them developing their expertise, and we can think about that through ECN. But if they get asked for more opinions, and those opinions later get tested in court, they will grow in experience and their ability to make sensible judgments. In our system, some forms of aid must be tested by the Competition Markets Authority. Some, you may send a voluntary question. However, the minister can override that and still do the aid if the authority says they think it's illegal. It has to be tested by the Competition Appeal Tribunal. But I do think it's a question of having experience in the authority to make referring to them worthwhile.
I think there we've also seen that there is a lot of different experiences depending on which country and which authority. Some are very much involved in state aid and have very dedicated units, others not at all. So Depending on the member state, maybe you might have a big benefit in involving the competition authority and asking, but in other member states not so much because the experience is not there and also just they don't deal with it in practice. So in that sense, we probably also have a benefit in developing to a certain extent a centralized unit in each member state that gathers a bit the expertise rather than having it in a very different way organized in each member state, I guess.
Maybe to come back on your question, if I may, indeed, the court did not really follow the opinion which was given. I won't enter into the details of the case, but I mean, that happens. Sometimes commission decisions where we also express no opinion, what we think is right, are questioned. Sometimes judgments are overturned. So, I mean, that makes it fascinating for state aid law. It's a constant look and search. And even if we thought we were right, I mean, at a certain point, the court may think or see it otherwise. So I don't think you should see this as a risk for not asking the opinion to the Commission. We share what we think is right, but then the court may have another opinion. That happens. Other questions, Jacques?
Yes, I would like to comment on the national authority, national competition authority. Since the enlargement in 2004, all the ex-new member states, they had national state legislation and they train a lot. They are good example and they know what they do and they prepare well notification, etc., etc. But they don't have no power of decision, which is good. In all member states, they don't know that and they are not competent and they have no knowledge. Now, it's there we have an issue with state aid versus antitrust. State aid is a competition law which is applied against the interest of the state. Antitrust is competition law applied in the interest of the state. In summary terms, I don't trust national competition authorities to apply state aid law. They are not fully, they're not independent enough to decide against the interest of the state, because this is that state aid. So we should not continue too much to hope that national competition authorities could be a help, it could be a help and advice, but their client are the state, in fact. So judges are independent, or should be, and they are, and I trust them. That's the solution. So be careful about any decentralization of state aid to national competition authority. It doesn't work. I don't trust that.
And maybe add one other thing. When we discuss the difference between antitrust and state aid law, when we discuss, for example, the harmonization of national law in order to allow the enforcement of state aid law, we should not forget that the concept of state aid, the notion of state aid is very broad, leading to, for example, taxes being state aid, or social security contributions being state aid, or private law instruments like contracts being state aid. So I'm always a bit skeptical when we compare the system under antitrust and state aid law and the competition authorities under antitrust, and discuss whether they would be useful to be involved in state aid law, because state aid law is a different, like, at least that's my opinion, comes from a different background. Like, state aid is about the state granting money to a beneficiary, and indeed, as Jacques says, the antitrust is about undertakings. And working and engaging with each other. And state aid law touches upon so many fields of law, not only the classic competition rules, but also tax law, social security law, private law. So we should never forget is that it's not completely similar. Maybe other panelists want to add on that or counter my argument, I don't know.
I guess
counter?
No, no, never, definitely not counter, but I guess the benefit of the national authority, if there would be a unit specialized in state aid, would be more in advising the local authorities when granting, when you have managing authorities or local granting authorities, as there in a country, usually there are so many different authorities dealing with state aid depending on the topic. You cannot expect all of them to really specialize in then also the state aid rules. So I think that the benefit mostly of these competition authorities, of specialized units, lies in then also advising more the granting authorities than the judges. I guess that's the main takeaway.
Yes, I think that's a very good point, because our experience is that some are big national cases and some are very local. And it may just be that the local authority doesn't have a big state aid department to advise it on whether what it's doing is lawful or not. So they do need help from somewhere.
And maybe last point, we should remain, again, positive. Just to use my own country as an example, for example, Belgium, not a good student in the EU state aid law course, but Belgium, the federal government in the coalition agreement, at least has the intention to set up a state aid center for expertise to think about how can we implement the state aid rules in Belgium in a better way than we used to. So again, as the main message should be, we should remain positive, but critical, of course.
Okay, thanks. Maybe one last question? No, not anymore. Ah, yes. Sorry.
Yes. My name is Miguel Muñoz. I'm a partner at Cuatro Casas. It's a Spanish legal firm. I practice state aid law, but in a limited field, because I mainly deal with tax state aid, which is a subject that is increasingly important, as we have seen this morning. I think there is something that has been mentioned in different ways in the different interventions on the panel. It's related to this Solomon judgment was the term I think you used. So the problem and the basic paradox of the state aid regime, in my view, is that the one that breaches EU law is the state, but the one that pays the bill is the beneficiary. So maybe it is time to revisit the rules of recovery of state aid and taking the view of the objective of such recovery, which is the reestablishment of the level playing field in competition. What I mean is that in some cases it is easier to expand the aid rather than to recover it. And it is clear in tax cases in which in many times the beneficiaries are many more than the ones that suffer, that competitors, sort of speaking. We have some cases in Spanish law, and there are some new taxes coming, in which the taxpayers are a very limited number, and the one exempted from the tax are very wide. So in those cases, a good solution for this Solomon judgment and for the actual application of state aid would be to challenge the criterion established by the Court of Justice, in which you may not claim state aid in order to be discharged from a tax. Again, I'm focusing on tax cases because that's my field of practice, but probably it is applicable to other state aids. And it is for the national judges to bring the cases before the Court of Justice in order to revisit that case law of the court. I don't know if any of the panelists have a view on this possibility on whether it could be successful. Thank you.
I don't know if any one of you can provide a short answer on that.
An answer, I'll try to be short. Yeah, we should not forget that the reasons why we have EU state aid law. So just allowing certain taxpayers to keep an advantage, it's a dangerous path, I think. This is something discussed in academia and at conferences. Like, how do we solve this flaw in EU state aid law that that the fact that the member state violates the law is in a way rewarded, but because it gets the money back with an interest. One idea one might think of is, for example, let not the state recover the aid, but the Commission, and that the advantage goes to the European budget. And then member states would, of course, still have an incentive to follow the rules. Of course, then we have to change the entire system, and member states will never allow this, of course. But we can discuss it further over lunch. Maybe others want to contribute?
Yes, I'm minded to think of our sugar case, where British Sugar, who have 50% of the sugar market in the UK brought an action because they thought Tate and Lyle, who import sugar cane for long-standing historic colonial reasons, got an advantage on tariffs. And the court said, hold on a moment, there's nothing to stop you going and importing sugar cane. You don't have any capacity to refine it, but you could.
Okay, thanks for this. I mean, maybe we can reflect on some of the issues. I think money going back to the Commission is, for the moment, not within my remit, and certainly not of the Commission, but maybe it would help some budget issues, but I think this is rather difficult to imagine in the current state of law. Thank you all for your very valuable insights. Let me invite you for the lunch now. We start back at 2 o'clock. Thanks a lot.
Thank you.
And I have the pleasure to moderate the first panel this afternoon that will discuss the obstacles to the application of state aid rules by national courts and claimants. Now, why is this panel important? You know that even though that courts are competent to apply directly Article 108.3, in practice, competitors often bypass national courts and opt to go to the Commission as their primary avenue in challenging unlawful aid. And this raises a couple of questions. So what are the obstacles arising in national courts? And are there any structural weaknesses in the direct application of Article 108.3 that may either discourage claimants or pose challenges for the work of the courts? And to unpack this, we are joined here by 3 prominent experts with unique perspectives. Leo Flynn is the director of the aid team of the Commission's Legal Service. He has vast experience in state aid and regularly delivers speeches and lectures on the subject, and he will explain what are the limits actually that to private enforcement based on the current state of EU law. We have with us Alvaro Pliego-Selli. He's a partner at Freshfields Amsterdam office. Also his extensive experience, this time in state aid litigation. And from the vantage point of Competitors Council, Alvaro will analyze the strategic trade-offs, whether you file a claim in national court or whether you submit a complaint to the Commission. And he would probably explain why one route so often dominates the others. And we have Judge Danielle Severinsen, member of the Stockholm District Court. As a national judge who has been dealing with state aid cases and their complexities, Danielle will focus on the main challenges in applying state aid rules and on the practical and strategic choices to be made in terms of the cooperation with the European institutions. Let's begin the discussion with Leo's intervention. Leo, the floor is yours.
Natalia, thank you very much. Good afternoon, ladies and gentlemen. It's a pleasure to have been invited to speak here at this conference, which I think is dealing with a topic that is perennially timely and certainly extremely significant. I think that several of the remarks that I'm going to make will probably be picking up on the threads that have been laid out in interventions before lunchtime. In particular, I would like to emphasize that our focus here is on the work of the national courts. And that's absolutely right, because the national judge, he or she is the face of union law, in reality for most individuals and most businesses most of the time. But by definition, a case comes to a judge only when we are in a pathology situation where at least somebody considers that something has not gone right. And that then pushes us further up the ladder to the public authorities who themselves, as Jacques Derrien underlined earlier on, have a full set of obligations to ensure that union law is applied fully and without the need for prompting. And so from that point of view, yes, the Commission is there, and yes, the union institutions are there as sources of law in the case of our other institutions, in the case of the Commission as a partner in terms of the proper administration of union law, and with particular and special powers in the field of state aid, special powers that are given to it under union primary law. But from a structural point of view, of necessity, the union legal order rests on a very high degree of decentralization, decentralization without fragmentation. That's one perspective, I think, that has to be kept in mind. Namely, as I say, that the national judge is the ordinary judge of European Union law, and state aid from that point of view is no different from anywhere else. The second organizing principle that I would like to keep in mind is that although when we look at litigation in front of national courts, of necessity, there is something of a national perimeter that is placed on it. We can't lose from sight that the state aid discipline is something that operates in a union context. For example, the criteria for the presence of state aid, advantage, selectivity, those are things that are basically on a member state specific terrain. But when we're looking at distortion of competition and when we're looking on effect on trade, we are looking beyond the confines of the individual member state. And if we take a step back and we're talking about the grand themes, I very much concur with the voices who were saying before the lunch break that state aid is indeed embedded in the parts of the treaty on competition, but it is nevertheless a special kind of competition measure. It is a competition measure that operates on two distinct levels. There is the one that is a more immediate concern to the private practitioner, who is probably the one in many instances who is going to be persuading her client to go in front of a national judge. And that perspective of the private practitioner stroke the client, I think, is nicely encapsulated in the Montessori judgment, when the Court of Justice speaks about the right of the competitor not to be faced with unfair competition as a result of unlawfully received state aid, which may indeed be incompatible. So that's one level of competition, competition in the market between those who have aid and those who don't. But the state aid discipline also functions as a means in which we have a mechanism for at least channeling what would otherwise be untrammeled competition between the member states, where the member states, rather than competing on their merits of what they have to offer in the internal market, would seek to illegitimately influence where investment decisions take activities to or take activities from. Those background considerations, I think, are then important because that then means that when we drill down into the role of the national judge, the national judge is there on the side of, as it were, two sets of players. One is the abstract theme of the rule of law, ensuring that the rules are upheld. And here, the rule that is critical, of course, is the rule which is set out in Article 107, paragraph 108, paragraph 3, with the dual obligations of notification and standstill. And probably, in practical terms, it is standstill that is actually the one that is critical. Although, as a reference from a Belgian court a number of years ago in the Vervloed case showed, it's not always easy to disentangle them. The national judge is there for the rules to be upheld, because she is the avatar of the rule of law, and that is the fundamental foundation upon which our internal market in turn rests. But as well as being there for the abstract rules, they are the ones who are policing and protecting the rights that flow from 108 paragraph 3. They are the ones who are upholding the rights essentially of interested parties. Against that background, we have to then keep in mind that there are some things that are common to national judges and the Commission and others who are applying the union law rules, and some things that are off limits to them. What is common is determining whether we are in the presence of state aid. And as we all know, the national judges, in dialogue with the Court of Justice, have been fundamental in actually shaping what we mean by when a measure constitutes state aid. I think that there's a certain Polish court that can be very proud of its contribution recently to the question of when do tax measures give rise to state aid, where that judge is basically behind a big development in union substantive law on state aid. So the national judge is free to identify that a measure constitutes state aid. More critically, the national judge is also free to determine, and indeed must determine, whether notification is required. So that could mean that we are looking at the question, is it aid, no aid? Is it existing aid? Is it new aid? Is it aid which is covered by an authorization given by the Commission in an individual decision, which would then mean no notification? Or is it something that is covered by a block exemption? But the notification, non-notification space is one where the national judge has a full set of powers. Where the national judge moves out into an area where they can't operate is simply asking the question, should this be compatible? That is not something that is within their powers. And then finally, to sort of close my loop, the national judge in the state aid context must facilitate the full implementation of union law, primary law and secondary law, not just the standstill obligation, but also, for instance, the full execution of decisions on recovery, or the, in addition to asking in the context of recovery, how do I facilitate the execution of this decision? It can also be in the context of an opening decision. I have an opening decision there. It is not a final position, but it carries with it legal weight, as we know from Deutsche Lufthansa. So it's a situation in which there's a series of common tasks and shared responsibilities, where certain things are off limits, one would say, for the national judge. But I have the sense that national judges are indeed thoughtful. In general, the questions that are posed to the Court of Justice, the requests for opinions that are made to the Commission, show that national judges may not be experienced with the tools of state aid, but they have the openness to ask questions. And from that point of view, and saving the blushes of a fellow panelist, in a certain sense, I think a perfect example of the kind of questions that should be asked, and also a very nice illustration of not asking questions that shouldn't be asked, are the ones that were put to the Court of Justice involving the operation of canals in the Stockholm region recently, but maybe we'll hear more about that later on. The final remark I will make is that something that has become evident in recent judgments of the Court of Justice is that the European Union legal order is not looking to pursue individual substantive rules at all costs. One of the things that we see in, for example, references coming from Italy on whether the national authorities can identify who is an economic successor to a beneficiary, so the Sky case, or a reference from Latvia that was already mentioned today in the context of asking of what is the effect of challenging a wrongful refusal of eligibility for state aid in the Toda case, or indeed the reference that came from the Romanian courts in on-air media on when I'm pausing for a moment because intellectually I have no difficulty with this, but it's a little bit hard physically to say it out loud. When the Commission gets it wrong, which was basically what underpinned on-air media, what are the consequences of that? And in all of those judgments, Sky, Toda, on-air media, what I find very interesting is the way that the court looks not just at the state aid discipline, but also when it is giving its answer to the national court, it combines it with the charter. Because ultimately we can never get away from the need to ensure that we are not just applying the rules that are laid down, but we are doing so in a manner that respects the rights and obligations of individuals and businesses, and that the responsibilities of the public authorities match with those fundamental freedoms.
Thank you very much. Thanks, Leo, for that those first observations. As mentioned, I will delve into a bit more the side of the private practitioner advising a company, because it's usually often a company considering to challenge perceived granting of unlawful aid, non-notified aid to often a competitor or a different situation. My practice is broader than state aid, as for many people acting in competition law. So, just 1 second. Sorry. Okay, sorry. You have the right name now with the image. I also advise companies on issues like enforcement of the cartel prohibition, abuse of dominance, but also outside competition law, unfair trading practices. And the reason I say that is because I think many of the issues I would cover, you face actually very similar questions and issues if you're considering whether to go for private enforcement or to try to stimulate public enforcement. So while I agree with Leo that obviously state aid is a bit of an animal of its own within the competition law area, if it's sort of from the perspective of a company that needs to go out there and accuse competitors or other parties of doing something wrong, there are often very similar dynamics at play. I will come back to that at the end. So very briefly to set the scene, I'm a practitioner in the Netherlands. If there's a potential state aid issue you want to complain about, there are basically two options, as you know: filing a complaint to the Commission, or going to the national courts in the Netherlands, where basically there are also two routes depending on the situation. So one is to go to administrative court in case there is a decision of an authority granting aid which can be challenged, which means you get into the administrative court system, often 2 instances, or if there's no challengeable decision, then you need to go to a civil court. And then it's actually 3 instances, so district court, appeals court, all the way up to the Supreme Court. So that is already sort of a different positioning towards the company, setting the scene. What are we actually getting ourselves into? You can imagine that, let's file a complaint to the Commission sounds very different to a company than, let's go to court, but it may take many, many years, and we might have to litigate at 3 instances. So then zooming in a bit more on sort of what are the considerations at play. The first one I would mention, and it's not a coincidence I would mention that first, is what I would call the reputational and relationship aspects. Dealing with many companies on a daily basis, I think it cannot probably be underestimated nowadays that while legal departments are important, there are departments like public affairs, governmental affairs, that at least have almost an equal say sometimes and have the ear of the CEO as well. And you know, let's face it, going to court is scary, right? It's just scary, and in state aid it's super scary because you need to confront the public authority typically and a competitor who may also be, you know, a business partner in another different situation. So very often dynamics, especially and also when public affairs people are involved, and it's not just about sort of the pure legal aspect of it. Companies are inclined to think it's, you know, maybe it's best to file a complaint with the commission. That's also not an easy decision to take. It's also to an extent confrontational, but at the same time, it is much more indirect. You file it at the commission, and then obviously it's the commission hopefully reaching out to the member state, reaching out to get the information. And in terms of PR narrative, to use that horrible term, it is easier for a company to then say, you know, we just raise questions, we are not the experts, we put it with the experts in Brussels, they'll investigate. And that is, of course, very different from going to national court. Because first of all, you're quite literally placed opposite to a public authority that you may have that you will have relations with, opposite to a competitor, beneficiaries that you may want to preserve relationships with as well, and you need to confront them directly. And not only do you need to confront them directly, but you also need to say definitively and very sort of aggressively that there is unlawful state aid being granted, right? So whereas maybe in a complaint situation, you might sort of provide building blocks to the commission and say, I have reasons to believe that, please investigate. Obviously, it needs to be a serious story. When you go to the national court, you actually need to say it yourself publicly, and you need to defend it, and you need to answer media inquiries about that. So I just mentioned those sort of relationship, reputational elements as a first thing, because I think in practice they play a very, very big role. Then the second point is, of course, the other investments needed at stake. All right, so company will typically look at litigation as an investment, look at what are the costs and risks and what are the potential returns. As one investment decision was already mentioned, that is sort of the cost of the reputational cost of litigating. But then there's, of course, other investments related around costs, legal costs, time, use of company resources to actually fight an issue. And there, again, at least perceived, I think, with companies, it's often more attractive to file a complaint with the commission because obviously then there's not the burden of proof, as mentioned. You file a complaint, you need to do a lot of work on it, you need to follow up with the commission, obviously. But that is seen as an effort that is usually relatively overseeable. Whereas, of course, if you go to court, you typically need to fight the case all the way to the end, insist on appeal. And importantly, of course, the burden of proof is fully with the plaintiff, which means that you need to establish in court that all the criteria of finding aid have been met, including the complex issue of often of selective advantage. Rarely the presence of aid is entirely clear-cut, and that means you need to invest in working with the company to pull the evidence together, the storyline, engage external experts, and then obviously presenting that in court. An issue related to that is access to evidence. Of course, most of the time, not all of the key information is available publicly. Let's say there's a private land sale, or you have reasons to believe that someone has a favorable tax ruling. Usually, not all the information is available. And then again, through the complaint mechanism, of course, the Commission can use its extensive powers to investigate. While if you are going to a national court, typically you will have difficulty gathering the evidence. Looking at the situation in the Netherlands, traditionally we have quite a restrictive regime on disclosure, discovery type of access. This is not something that courts traditionally like a lot, so it's also difficult in that way to gain access to information that is available only within the member state or at the beneficiary, for example. Another element in terms of investment I already alluded to is the duration, so the time investment. So again, much more overseeable for a company to file a complaint. Obviously that can take years as well and has an uncertain outcome, but it just sounds much more challenging if you have to explain that you might be litigating in 3 instances, different hearings, rounds of written briefs, all the way up to the Supreme Court. So it's also the commitment that you enter as a company that you already know that potentially if this is litigated fully, you might spend 6 or 8 years in the court system within the member state. Then maybe moving to sort of the lack of a positive track record, and a lot has been said about this already, so I won't go over that in any detail. But simply put, there are just not so many positive outcomes in the Netherlands, at least in state aid cases. There are, but there are not very many. And that's, of course, a bit of a chicken and egg problem. But there are just quite a number of cases where the outcome was that the courts rejected the application. And as mentioned, many reasons have already sort of tried to explain why this happens. But one that I want to highlight is the issue of the strictness that especially civil courts apply in terms of the burden of proof, but also in terms of admissibility. So it's raising the bar, leaving the burden of proof fully with the plaintiff, but also being quite strict on sort of the evidence that needs to be submitted in order to demonstrate that you are a competitor with standing. I was quite surprised actually to read a couple of judgments even this year about private land sales, which were challenged by a developer that didn't get the land from the municipality, that were basically thrown out of the court, and because the court said very strictly, you haven't submitted enough facts and circumstances demonstrating that you're a competitor. For example, because you're active typically in agricultural land, whereas the one who got the land is in urban development. So really raising the bar. And without trying to explain all of that, but I think that part of that is also sort of a lack of appetite that still prevails, especially in many civil court judges in the Netherlands. So then rounding it up, the conclusion, as mentioned, quite a lot of challenges, a lot of reasons in practice to either do nothing, of course, or to file a complaint with the Commission. Sometimes that's also, frankly put, a bit of a compromised position then within a company for the reasons mentioned, less confrontational, maybe less of an investment, and still the legal department can tell the stakeholders in the company, we are doing something serious here, we're fighting on this issue, but without sort of going all the way. And then very briefly to think about, if you want to move the dial on this, what could be sort of changing this? Maybe first of all, one reflection based on dealing sort of also with other areas of European law. I don't think state aid is unique in this. I mean, private enforcement of the cartel prohibition, abuse of dominance prohibition, standalone cases in civil courts in the Netherlands is also very limited, faces a very high bar. And again, the reputational issues of challenging your competitors in court or your suppliers set a very high bar for that, and typically it's easier, more attractive to file a complaint. So it's not a unique situation, but areas where I think the landscape could improve, at least in the Netherlands, are first of all, maybe damages as a carrot. So we need examples of damages being awarded, because that, of course, creates an additional incentive to litigate if there's a carrot at the end of the road, in a financial carrot. Another element is, I think, helping on reversing the burden of proof. So judges working with, where possible, with presumptions, or allowing sort of the burden of proof to turn when a minimum set of facts and circumstances have been presented. There's a judgment of 2020 of the District Court in Hague, 23 December, where exactly this happened in a land sale context. The court said, I see a couple of factors here. There's no taxation being done, for example. Now I'm going to reverse the burden of proof, and now it's for the municipality to demonstrate that it's not state aid. I'm not saying this will work in each case, but that type of judgments help litigants getting more sort of excited about the prospect of litigation. I probably have reached my time limit, so I'm going to close off.
Thank you very much, overall, for these detailed and nuanced considerations for claimants. This risk-averse image of public enforcement is bringing a lot of thoughts, I think, for the panel and for the future of enforcement.
So thank you very much for inviting me as well. Special thanks to Leo for the kind words regarding my referral to the European Court of Justice recently. I will talk a bit about it very shortly. As you heard, I'm a judge from Stockholm, Sweden. I work mainly for the Patent and Market Court, handling IP cases and competition law cases. Sweden doesn't have specialized courts for state aid cases, as we heard about this morning. Most member states don't, but if a case comes to the Stockholm City Court because the defendant has its domicile there, for example, damages state aid claims against the state, then us judges from the Patent and Market Court would handle those state aid cases, sitting as the Stockholm City Court, because there are some overlaps, at least, between state aid law and competition law, as we've heard. Also, full disclosure, for the past almost 10 years, when I have been with the Patent and Market Court, Stockholm City Court, we've had in total 3 state aid cases, 3 civil state aid cases. I've handled 2 of those cases, and some of that makes me an expert because there's so few state aid cases in national court in member states, which is the whole point, or one of the main points of this conference. Also, when I'm here, I would like to thank Adam, of course, for talking about our Association of European Competition Law Judges, etc. I am currently the vice president, and therefore I also want to take the opportunity to real quick just say how important our organization is for us national judges, being able to exchange experiences, discussing trucks, cartel damages claims, or whatever it could be. We are also extremely grateful for the Commission for our support. Without that support, I'm sure it would not be as well functioning as it is. So thank you. So damages cases in the state aid area. I had one such case a couple of years ago. A company called Familjeakademin, translates to Family Academy. They were offering courses for parents in Sweden, and then the state, through the Public Health Agency, granted certain municipalities about 13 million euros to provide similar free courses for parents. This was not notified to the Commission. And according to the Familjeakademin, this was illegal state aid, then in breach of Article 107, so they requested 1 million euros in damages for loss of profits. And the Familjeakademin argued, they had help by a professor in European law. They argued that competition had been distorted, the recipients of these grants had been given sort of an unfair advantage over Familjeakademin when they received these grants. Familjeakademin also claimed and had evidence that demonstrated quite clearly that their turnover had dropped rather rapidly after those grants were distributed. But still, there is, of course, also the matter of quantifying damages. You have to establish the direct causal link between the unlawful state aid and the damage suffered, etc. In this case, Familjeakademin stressed that it's very difficult to establish what the counterfactual scenario would have been with any certainty. They held, similar to what Alvaro just talked about, that even though perhaps the burden of proof shouldn't be reversed, they claim that the standard of proof should at least be lowered because it is so difficult to demonstrate what the scenario would have been without those grants. It would perhaps have been easier if they only competed for a certain contract and someone else got it, but this was not the case here. And they also claim that my court or I should use the possibility that Swedish courts always have in damages cases to estimate harm similar to what you can do according to the damages directive. Another matter arose. Familjeakademin, the claimant, requested a preliminary ruling regarding several questions. It concerned whether the grant from the state was indeed state aid, whether there had been an obligation to notify it, and whether Familjeakademin had the right in principle to damages under these circumstances. And here I actually denied that request. Quite brief reasoning for denying the request. I thought it was not necessary with the preliminary ruling to give a judgment. To me, it was quite clear, at least, that in principle, Familjeakademin would have the right to damages under the circumstances. But one important factor was also that the claimant and the defendant, the state, disagreed on most, or at least many of the relevant facts, which made me think that perhaps a preliminary ruling would not have been as helpful as it could have been. In this particular case, no one raised the question of asking the Commission for a non-binding opinion. And I must admit I didn't give that much thought either in this particular case. And we were planning for a main hearing, but in parallel to that, there were also settlement discussions between the parties. And actually, the case ended, partly successful at least for the claimant, with a public settlement judgment, and that is why I can talk about it. There's nothing confidential in it, where the state paid not 1 million euros, but 25,000 euros approximately to Familjeakademin. The state did not admit to the grants being unlawful state aid or anything. They just paid this lump sum. And also in Sweden we have the loser pays principle for litigation costs, but in a settlement ruling, each party has to bear its own costs. So partly successful damages case, even if Familjeakademin did not receive at all as much as they claimed. And this is the only Swedish successful state aid damages case that I'm aware of, at least. And then there's another interesting case, I think, where I am the reporting judge. It's a pending case, so I will be very neutral when I just present the facts, basically. This is the case that Leo mentioned just now then, where the state, through the Swedish Maritime Administration and the public undertaking, the Stockholm Port Authority, they agreed that the Port Authority should not collect fees for vessels passing through a certain lock in Stockholm, a lock between the Baltic Sea and Sweden's third biggest lake, Mälaren. And since the Stockholm Port Authority would stop collecting fees, the Swedish Maritime Administration paid yearly compensation to the authority for its loss of income. This was between the years 1979 to 2022, so it was well before Sweden joined the EU in 1995. The original agreement was extended every 5 years if none of the parties terminated it. There were certain adjustments to the agreements according to consumer price index and also according to how many boats had been going through that lock for the past years. And then after over 40 years of paying compensation to the Port Authority, the Swedish Maritime Administration terminated the agreement and also requested reimbursement of the compensation it had been paying for the past 10 years, and 10 years because of Swedish limitation periods. And the claim was based then, of course, on Swedish Maritime Administration realizing that this was in fact unlawful state aid, and then they have an obligation to request reimbursement. Of course, they have to do it. And the amount for the past 10 years was approximately, well, it was a bit less than 4 million euros. And here, after some exchanging of documents, I had a case management hearing where I actually myself raised both the matter of asking the Commission for a non-binding opinion or requesting a preliminary ruling from the Court of Justice. And I can say that the parties, they weren't applauding my suggestion initially. They were concerned about the delay and also about costs that they perhaps wouldn't get recovered from this delay. But in the end, they didn't argue against it either, and they both agreed that they preferred a preliminary ruling from the Court of Justice. One reason for this, of course, is that such a ruling is binding on the national court, whereas a Commission opinion is not binding. I informed them that the Commission would probably issue an opinion in about 4 months, whereas the Court of Justice usually needs up to maybe 18 months for a preliminary ruling. And that's also, it was in the end a preliminary ruling. It took about 18 months. But one important reason for requesting a preliminary ruling and not asking the Commission for an opinion in this case was that one of the questions I wanted to ask concerned Sweden's accession agreement to the EU, and that's of course for the Court of Justice to interpret and not for the Commission. So in the end, that is what I asked. There were questions regarding the concept of undertaking and selective advantage, and also what we heard about this morning, the difference between qualifying aid and also what's the amount of the aid. And the Court of Justice just a few weeks ago delivered their judgment, and they answered these questions to some extent. They also interpreted the accession agreement and also gave some advice on whether it was new aid since it was extended every 5 years, but as usual, it's still left for the referring court to examine various factors, of course, and we'll see where this goes. I can also say that even though this is a case where the state has an interest, of course, I have experienced zero pressure. I think I have never heard from a colleague who has experienced pressure in any civil case in Sweden from the state, which is, of course, a good thing. To round up, I'm also briefly mentioning another high-profile case that was already mentioned this morning, Scandinavian Airlines against the state. This is not my case. A colleague is handling it. I have no inside information. And briefly, the facts again is that Scandinavian Airlines received state aid from the Swedish and Danish government during the COVID-19 pandemic. This was approved by the Commission August 2020, but another airline filed a complaint with the General Court, who annulled the aid in May 2023. Then it was reapproved by the Commission in November 2023. It was annulled by the General Court, as I understand it, due to a procedural error. And here already in its summon application, Scandinavian Airlines requested a preliminary ruling from the Court of Justice, and in its statement of defense, the state agreed, yes, this is absolutely a situation where we should get a preliminary ruling from the Court of Justice. There was some discussion, I understand, as how exactly to put the questions, but parties agreed. They didn't raise the matter of asking the Commission for a non-binding opinion instead. But of course, one argument for that could be that it is the Commission's decision to first approve the aid and then to reapprove it that is sort of the cause for the whole case, whether Scandinavian Airlines should pay interest or if there are exceptional circumstances, etc. This request was made about half a year ago, and I don't have any news about how that is going. Perhaps someone else has on the panel even. So these are the 3 state aid cases we've been handling in Swedish courts. Thank you very much for your attention.
I would like to now open the floor to comments or questions to our panelists. Please, could you please present yourself and indicate to who your question is going?
Thank you. I'm Antonia Vecht from Houthof, located in Brussels. Okay. Okay, now it's on. Antonia Vecht, Houthof, located in Brussels. I had a question for you, Alvaro. What you mentioned with regard to the information asymmetry in damage proceedings. And as you're Dutch, I'm sure you're aware, but it reminded me of the judgment that was rendered last week by the district or the Court of Appeal in The Hague with regards to the dairy cattle. So very short, what it was about, it was the extending of phosphate rights that was approved state aid. And the claimants basically claimed that the state unlawfully broadened the definition of beneficiaries by treating meat cattle as dairy cattle. And the Court of Appeal approved the disclosure request filed by at least one of the plaintiffs with regards to the documentation shared between the member states and the Commission regarding the state aid. And I was just, also in Leo's, I was just very curious about your comments and thoughts about this decision, in respect to your previous comments.
I must say I haven't seen the judgment, so in that sense I'm going off what you say. It's very interesting. I can also, my first reaction would be I can place it maybe a bit in a broader trend, which I think we're seeing now more generally in the Netherlands, also in the context of mass claims and the expansion of the disclosure regime by legislation in the civil context earlier this year, that we are maybe moving in a direction where courts are more active in supporting claimants generally, but then I think also in the state aid context of getting access to evidence, where we're coming maybe from a traditional system where this was very restrictive. I think we're seeing a shift across the board in that, at least in my experience with judges. And I think that's been spurred by mass claims arriving in the Netherlands and becoming sort of a significant practice, and a lot of that is of course imported from the UK and US experience. So I would place it in that context to be brief.
I would be brief, but again I would maybe make a more general observation. I don't think that from the point of view enforcement that state aid is such a special child compared with other topics of union law. And in general, union law operates on the basis that substantive rules that fall to be applied through this decentralized system, as I described it, build upon the national procedures and the national remedies subject to requirements of equivalence and of efficacy. So I actually am not troubled by the fact that there are different pathways, as long as, and this is where efficacy comes into play, as long as it works.
Thank you.
Jacques?
Jacques Dorin, I wanted in fact follow up Leo's observations on 2 points that we have not insisted. One, state aid, in state aid for unlawful aid, national courts have more powers than the Commission. And we should not forget that, and pleaders should not forget that. National courts are obliged in principle to take a decision and recover all the remedies in view of unlawful aid. And in view of unlawful aid, the Commission is less empowered they have to take a decision on substance. They have injunction, suspension, and recovery. Injunction, it never worked because the member states did it well in the regulation, make it impossible for the Commission to implement the Article 13. But national courts have more powers than the Commission. So that's, pleaders, lawyers should know that. And second point, state aid is the more powerful law in European law, because nothing is, in principle, resisting to state aid law, up to closer holds and Lucchini cases. From that, we can infer that even some general principles of law, which are not that general that absolute, the res judicata, should give rise to implementation of state aid law against legal certainty. And that's the only way, only place in European law where it has been stated, because there is an encroachment of exclusive power of the Commission and powers of national law. So if a national court takes a decision which is wrong against a decision of the Commission which cannot be implemented, the wrongdoing of the national court will not be definitive. And that's the only place in EU law that we have that exception. So I want just to take the news for some of us probably, that state aid is quite special. National courts, you have more powers, and state aid law is more powerful than anything else in European law. So take a lesson from that.
Who would you like to react to this?
Interesting intervention, but as someone said just this morning to me, that the judges don't bring the cases, so to speak, so it would really be for the lawyers to bring more cases then. But of course, it's a chicken and egg situation, like we just heard. If you bring those cases and then you tend to lose them, then of course clients would rather file a complaint with the Commission because there's lower risk.
There was, please.
Olivier Dormesson, I'm a lawyer in France, in Paris. I wonder if the allocation of tasks between the National Court and the Commission is right, because my experience of nearly 30 years of practicing state aid law in France shows that action before the French courts, when you have unlawful aid which has not been notified, is extremely difficult. It's an uphill battle. Why? Because first, for the courts to decide that a company has to reimburse, to repay a state aid, it's extremely difficult for the judge to judge that. But also because my clients, in many cases, has been subject to pressure from the French authorities, either to withdraw in one case, to withdraw a case which was well advanced, and the client had to withdraw all this case because it was asked by the French state to do so, and in some cases you cannot resist those kind of pressure. And in many cases there are indirect pressure, which means that big groups in France are so dependent of the French state that they hesitate, of course, to initiate case. They say to the lawyers, look, you may be right, but is it really worthwhile to do all those proceedings, very complicated, and we will have retortion, we will have a problem with the French state. When, thankfully, you have been able to convince your client to go to a French court and to do all the procedure, very often the French court, you have the impression that the French court and the Conseil d'Etat do everything they can in order not to recognize that there is a state aid. And I can mention several cases where the Conseil d'Etat has considered that there was no state aid, and there have been, there are rare cases, and there have been a later decision of the Commission that said, yes, there is a state aid, and in one case the state aid was approved, in one other case the state aid was prohibited. I have recently an experience with the Conseil d'État where the Conseil d'État has been extremely imaginative to find that measure was not a state aid. Very, very imaginative. So my question is, as it seems to me as a total failure, the Boussac case law, and that it's just coming from case law and then it has been introduced in a regulation, and this regulation could be changed. I wonder if it would not be good to say that it's the Commission that has the right to ask for the repayment of non-notified aid, of unlawful aid, and no longer the national courts.
Leo, maybe.
I'm going to start by saying that I entirely concur with the remark that you made towards the close of your intervention, which is to say that we're operating on the basis of a very slim primary law foundation, Articles 107, 108, 109, and they say nothing about recovery. And the reason they say nothing about recovery is because they have a procedural regime for existing aid, and they have, for everything that is not existing aid, for everything that has come into existence thereafter, they have a mechanism of notification. And it doesn't contemplate a situation in which you would have new aid that isn't notified. And so, as you say, what we have there are a set of tools that have been forged by the Court of Justice in dialogue with the national courts. And some of those are, as Jacques Derrien has pointed out, highly empowering of national courts, but that requires a willingness to use those powers. And they are also simultaneously limiting for the Commission, because the Commission cannot draw consequences from the bare fact of unlawfulness, because the Commission is not there to police unlawfulness. The Commission is an entity whose task is to ensure compatibility with the internal market, and where matters are not compatible with the internal market, that they're not put into effect. In other words, we're operating in a model in which there isn't, at least in terms of design, a space for dealing with recovery from that point of view. If we were starting with a totally free hand, to be honest with you, to be absolutely honest with you, I would not ask that the Commission be the one who is entrusted with the obligation to follow up on unlawful aid, because again, I will make the case. I am one of the most fortunate people in the world. I get to work on state aid law full-time. Could there be anything better than that? But at the same time, it's still not a special regime, I would say, within the union's legal order. The union legal order is of necessity decentralized. You cannot get the Commission to do everything, everywhere, all the time. It is neither desirable and it is also not feasible. There's no point in us even launching these kinds of ideas when the member states are unwilling to fully fund the union institutions to do what they already have to do, let alone us coming up with ideas about what are the extra things that the union institutions could be doing in the future. We have a situation of partnership, and we have to make this work.
Thank you. I think we should stop with this panel at this stage. It was just because of time. Thank you very much. Thank you.
So to introduce our very special speaker this afternoon, I want to invite to the podium our freshly appointed Deputy Director General for State Aid, Anthony Whelan.
Good afternoon, thank you very much. It is one of the oddities of bureaucratic organizations that someone you've probably never heard of who has been 8 days in the job is invited to introduce someone you've all heard of and is very well known. So I won't stay long at the job. Simply to say that it is with great pleasure that the woman who combines in one person both the role of Competition Commissioner and that of Executive Vice President for a clean, just and competitive transition will now take the floor to address you on the shared role of the European Commission and of the national courts in ensuring that state aid enforcement supports the rule of law, democracy, competitiveness, and our internal market, which is a lot. Thank you.
So good afternoon, everybody. It was my intention to come by surprise a little bit earlier, so to learn and to find out if I had to react to something, but you were too shy. I was not able to do so, but very honestly, it's a great pleasure to be here with you today, to count on Anthony as effectively being the new Deputy Director General in the House dealing with state aid, not new to the business, not new to the House, but yes, in this position. And yes, I think it is a great privilege to have a chance to comment with you some of the elements that we consider particularly relevant in this exercise that we need to implement together. We often talk about the big forces that shape our economy, and we refer to global markets, to new technologies, to climate change, to skilled workers, to the disruption of international supply chains, to the confrontation against the rule of law in different international contexts. But even if these forces dominate headlines and policy debates today, I think it is important to focus on something that in many occasions is not so visible, but it is very, very, very important because it is essential for fairness and trust in our union, to be sure that no matter what stakeholder, corporate operator, citizen feels the confidence of counting on reliable institutions and the enforcement of the rule of law wherever we live and on whatever circumstances. So yes, I think that the role of national courts and of private enforcement in upholding our stated rules is absolutely essential. The courts are essential to ensure the application of the rule of law under whatever circumstances, but this is also truth when thinking, when talking about state aid. Yes, the courts are understood by any average citizen as a cornerstone of our democracies. Courts' action can prevent powerful interests from bending the system and ensure that competition in our single market is fair, open, and honest. So able to thrive competitiveness, innovation, better protection of our citizens' rights, and to ensure a well-functioning market wherever we are. So our judicial system in our single market plays a very relevant role to be sure that every worker, every small business, every community has a fair chance. Also, to ensure that the market delivers and to ensure that the rules are fair. Enforcing stated rules is key for Europe's competitiveness, which cannot be achieved without fairness and cohesion. Yes, there may be many occasions where we identify that subsidies, state aid, can help to provide the right answer to a market failure. to ensure that we can accelerate things that otherwise would take very long time and could have an unfair impact. But it is also true that we need to be sure that it plays at the right level, at the right context, and with the right conditions. Why for competitiveness? Because the heart of our European prosperity lies in our single market. Despite its successes, it is something that remains held back by regulatory barriers. It is something that is still fragmented. And unlocking these barriers requires decisive action and genuine cross-border integration. That's part of the regulatory demands. That's also part of the enforcement expectations. We need a fair and competitive environment where European companies can scale up and where citizens can benefit from the full potential of the single market. And because the single market is our strongest tool for competitiveness, it must be governed by fair rules applied consistently across the Union and be transparent whenever there is something that can help into the day-to-day life of the citizens without providing distortive and selective advantages to a few and hurting everybody around. Workers may lose opportunities, business may lose customers, entire regions may lose investment, and Europe could lose on competitiveness. Ensuring proper enforcement of state rules is one of the main tasks of the Commission. But the Commission cannot do this alone. We need you. We never could, and we never should. Stated enforcement is a shared responsibility with member states, and national courts are absolutely central to this mission. National enforcement is a powerful tool. It complements the Commission's action, especially in relation to the smaller or more local measures that may never reach Brussels. Over the past decade, we have modernized state aid control so that the Commission focuses on the biggest, the most impactful cases. This has allowed member states to take more responsibility for smaller local measures, so typically measures falling under the block exemption rules. Today, less than 20% of all state aid measures come to the Commission for notification, compared to around 60% before the reform. And we are now looking into how to further simplify our GVER rules, making them more accessible, simpler, and fit for purpose for today's realities. We aim to have updated rules in place by the end of 2026. This means that national authorities, and especially national judges, are now more important than ever. You are, and you will remain to be the ones to see how the local economy up close. You will be the ones who hear from workers, from small business, from cooperatives, and from citizens that feel negative impacts or feel affected by unfair state support. You could be the closest to the people that we all collectively serve. In times of crisis, whether economic, social, geopolitical, governments tend to intervene more to support the economy, which is obvious, which may be needed. This support can even be indispensable, but it must remain targeted, fair, transparent, justified. Aid must go only where it is truly needed. And when mistakes happen, national courts are the natural place where citizens and business tend to turn. You ensure that exemptions are applied correctly, that aid does not undermine fair competition, and that people can count on different layers to protect their rights. You help uphold the rules that keep our markets open to all, not just to those that may feel more powerful. And it is true that the task is not easy. State aid cases require complex legal and economic analysis. And unlike other areas of the European law, there are very few specialized courts dedicated to this field. This is why the Commission remains committed to help through discussions, training, guidance, exchange of information, experience, platforms that can help to exchange views and to improve the quality of our decisions. It cannot be a one-way relationship. In the Commission, we need to understand the obstacles that national courts and litigants face. What you identify as the main drivers of any mistake, the main drivers of a successful decision, the concerns being expressed by the citizens and local corporates. And we must be ready to act, to remove them, and to act on a fair basis. So cooperation must deepen. Dialogue must become more regular. We need to meet much more. Sharing insights, like we are doing today in this setting, is essential. Let me also comment here on the work of the Association of European Competition Law Judges that promotes knowledge and understanding of competition policy and law among judges. By working together, we can overcome many obstacles that may prevent national remedies from being used to their full potential. And we can build a system where companies feel confident to seek justice at national level and where judges feel empowered and supported when applying stated rules. So let me make these very three final clear messages. Remember, national courts are essential players in state aid enforcement. We know it, we recognize it, and we could be more than happy to keep connected to you. The fact that private enforcement has been underused so far must not stop us from unlocking its full potential. Second, we must strengthen confidence. Business should feel able to seek remedies at home, and judges could help and should be fully equipped in using their powers. And third, the collaboration is key. By working together, Commission, national courts, European courts, stakeholders, we can make state aid enforcement stronger, fairer, and more effective. This is how we can safeguard fair competition, social justice, and shared prosperity across our union. So we count on you, but please do count on us. Let's ensure that we have a regular chance to meet, exchange views, experiences, and to keep on improving the performance of our day-to-day work. Thanks a lot.
Okay, new start. So the good news is that now we have a free-flowing panel, including Q&A. So allow me to introduce again the panelists properly. First of all, Clélia Jadot, who is associate in Shepherd Mullin and who has been extensively researching the topic. Clélia will present the legal framework of damages actions, followed by Nicole Robbins. Nicole is a partner and head of the state aid practice in economic consultancy Oxera. She has extensive financial and economic expertise, and she will provide us with a real toolkit, economic toolkit of the theories of harm and damage quantification. And Charlotte Michelet, partner in law firm in Paris, in McDermott. She's specialized in public and administrative law, and she has the chance of having seen through one of the rare successful damages actions in front of the French courts. So we all are very keen to hear from your takeaways and from your practice. So Clélia, the floor is yours.
Thank you very much for So thank you very much for the invitation. Judge Severinsen already presented a concrete case of damages in the state aid field, but as Diana already told you, I will give a general overview of the legal framework in damages action in state aid cases. So the first observation I'd like to make is the stark contrast between theory and practice, because on paper, actions for damages are clearly provided for and possible under EU law. And in reality, we see that there are very, very few cases of awards of damages in the state aid field. It's a point that is made right at the outset of the new enforcement notice, where the Commission addresses it in the broader context of remedies available through private enforcement of state aid rules. The Commission explains that since the state aid modernization agenda in 2012, they focused their ex-ante control on cases with the biggest impact on the internal market, and in parallel, more exemptions from the requirement to notify have been created. However, this comes with an important trade-off. It raises the risk of incorrect application of state aid rules by the member states. And in that framework, the Commission itself has highlighted the importance of the role of the national courts in ensuring compliance with state aid rules. And Executive Vice President Ribera also highlighted it today again, especially in light of the new GBER reform coming in 2026. So we could think that private damages action are gaining in importance. And in practice, it's rather different. We already saw that the 2019 enforcement study shows that damages awards are truly exceptional. And this has two serious consequences. First, most harmed third parties remain uncompensated. And second, this doesn't create any incentive for member states to respect the state aid rules more strictly. So before presenting the legal framework, I just want to draw a distinction between three types of action that are conceivable in the field of state aid. They are the actions between competitor or third parties versus member states, between competitor, third parties versus beneficiary, and between beneficiary versus member states. And the EU right to obtain compensation only exists in the first type of action because the obligation to notify and to suspend the implementation of the aid lies on the member states. So I will focus on that type of case exclusively. Under the EU case law, there are three conditions to obtain compensation from member states in case of unlawful acts or conducts of national authorities. The infringed EU rule is intended to confer rights on individuals. There is a sufficiently serious breach of that rule, and there is a direct causal link between the breach and the damage. And in this context, absent harmonization, as this has already been said, national rules apply to any damages claim, provided that the principle of equivalence and effectiveness are respected. So when you apply that to state aid, the first two conditions are easily met because Article 108 confers rights on individuals, and because when the national authority has no discretion under EU law, a mere infringement is sufficient to establish the existence of a sufficiently serious breach. So that is obviously the case in the state aid field. However, there are significant hurdles for the third condition. So really the issue is about the direct causal link between the breach and the damage. So, the first obstacle to overcome is proving unlawful state aid. And its existence often requires a complex assessment. We already saw that there are multiple layers the existence of state aid, the application of the GBER, and what can be difficult is the asymmetry of information between the claimants and the member states. In this regard, there are some elements that can help. You have the Boiron case law and the Commission decisions. So in the Boiron case, the court held that in order to comply with the principle of effectiveness, if it is impossible or excessively difficult for the claimant to produce evidence of the existence of state aid, the national court must use available national procedure to give the claimant access to the evidence, including ordering the production of a particular document by one of the parties or even a third party. That case is useful for all the obstacles, so not only for the existence of state aid, but also for establishing the causal link and for quantifying the damage. The Boiron case law was mentioned in the old enforcement notice, so the 2009 enforcement notice, but it's not anymore in the new enforcement notice, which is a bit unfortunate, as I believe it should be made as accessible as possible for national courts seeking guidance. The second element is the existence of a decision, and it's not only a final decision, but also an opening decision. So if simply a decision to initiate the formal investigation procedure will bind the judge to consider the measure as state aid, as was said in the Lufthansa and the Lübeck cases. However, this is kind of theoretical, because in practice, national judge, they will tend to order interim measures. They won't be at ease with ordering already like compensation if they know that in parallel the case is still being investigated by the Commission. The national judge may also seek guidance from the EU institutions. We've already talked about that, and that is for the next slide. The second obstacle is establishing a causal link. And there is an article which is very well written from Michael Honoré and Nana Eram Jensen. Basically, they explain the specific difficulty in state aid cases where there is a double causation. So there is the upstream causation and the downstream causation. While in antitrust field, you only have the downstream causation. So the upstream causation, it's the link between the grant of the aid and the damaging behavior, while the downstream causation is the link between the damaging behavior and the damage suffered. And in the first case, for the upstream causation, the difficulty is that the defendants are likely to argue that nothing proves that the aid specifically financed the damaging behavior. So the beneficiary would and could have acted without the aid. And in this case, what can be useful is a positive decision from the Commission. So even a Commission that says that the aid is compatible, in that case will be useful, because then the Commission will recognize that the aid had an incentive effect for the beneficiary. For the downstream causation, basically the big difficulty is the existence of exogenous factors. So for example, the competitive structure of the market, the fluctuation in terms of demand and supply, or even poor management by the competitor. And once again, you can use the Boiron case for any type of obstacle. The same issue of exogenous factors exists for the quantification of the damage, which includes the actual loss and the loss of profit. Here, for the quantification of the damage, the only guidance that we can find is in the enforcement notice, and the new enforcement notice is sometimes less precise than the old enforcement notice. So basically, both notices cover two scenarios. Either the aid enabled the beneficiary to win over a contract, or the aid merely leads to a loss of market share. And for the first one, the new enforcement notice simply says that it is easier to quantify the damage in that case. The old enforcement notice was a bit more precise because it suggested calculating the revenue, which was likely to be generated under the missed opportunity, taking into account the actual profit generated if the contract had already been fulfilled by the beneficiary. This can seem very basic for some of us, but for national judges who do not handle state aid cases on a daily basis, reminding them of that can be useful. As for the loss of market share, both notices suggest comparing the claimant's actual income situation with the hypothesis where there was no unlawful aid granted, but once again, this creates considerable uncertainty because the defendants will probably contest the counterfactual situation. Once again, the Boiron case applies, and here you can use, like, the new enforcement notice provides for the use of estimates by experts when national procedure allows it. So as I told you before, there are also the cooperation between national courts and EU institutions. I feel like we've already discussed quite a bit these tools. So I will simply mention that, for example, under the Article 267, there is an interest in turning to the court rather than the Commission in cases where the Commission has adopted, for example, an opening decision which binds the national judge, but the national judge does not agree with the qualification of the measure as state aid. That can be particularly useful. And as regard the request for information, request for opinion, for example, the Commission can transmit statistics, market studies, economic analysis, but often the Commission won't have performed such detailed economic analysis because it didn't need to. So sometimes it's kind of a bit frustrating for the national judge. In conclusion, despite the existing tools I have just presented, significant obstacles remain for claimants seeking damages in state aid case. And in light of this observation, I have explored possible avenues for regulatory reform in an article. So if you are more interested, you can still read it. Thank you very much for your attention.
Thank you. Nicole, the floor is yours.
Thank you very much, and thank you for the invitation. So I'll talk briefly about the use of economic and financial tools to estimate damages in the state aid context. And I'll focus mainly on the scenario where claimants are claiming damages from a competitor as a result of unlawful and incompatible aid. Now, from the economics perspective, there are three main steps in terms of the quantification. The first step is identifying the theories of harm to be tested. And this is, of course, once the unlawful aid has been established. So the claimants need to set out theories of harm that could be examined about how they've been affected and harmed by the unlawful aid. Now, these could be A, directly suppressing the price that the beneficiary can charge, and therefore that the claimant is allowed to charge. Although quite often in state aid cases, the impact of the unlawful aid might be more indirect. For example, it could allow the beneficiary to cross-subsidize its products or services, or it could mean that a company stayed in the market that would otherwise have exited. So the first step is really to identify the hypotheses to be tested, and that could include examples of such hypotheses could include whether the aid has led to the beneficiary pricing very low and potentially engaging in predatory pricing, or indeed whether the unlawful aid has meant that the company retains in the market, when otherwise it would have exited the market. As was mentioned earlier, if there's already a Commission decision, then this step would be particularly a lot easier. The next step is to look at identifying causal link between the unlawful aid and the harm, and has already been mentioned, that involves two steps. Firstly, looking at how the unlawful aid has changed the behaviour of the beneficiary, and then secondly, looking at how that change in the beneficiary's behaviour has harmed the claimant. And it's particularly important, as been mentioned as part of this step, to identify other factors that could have occurred in the market that could have explained some of those changes, such as, for example, changes in macroeconomic conditions. And then the final step is the quantification, which, excuse me, depending upon the legal framework, could amount to the lost profits, so the difference between the claimant's actual profits and those that it would have occurred in the counterfactual scenario. To illustrate the economic and financial tools that could be used to quantify the damages, I'll just give an illustrative example that I'll refer to, is where a member state grants various aid measures, which the Commission then deems to be unlawful and incompatible, as the aid is not found to be limited to the minimum amount necessary, so i.e. there's been overcompensation. The main competitor then claims that the unlawful aid has been used by the beneficiary to compete unfairly in the market by lowering its prices, which the main competitor then has to also follow. So the theory of harm in this case is particularly clear. In order to look at the causal link about whether the aid has harmed the main competitor, the first step of looking at how the unlawful aid has harmed the beneficiary would of course be a lot easier if there's a Commission decision already that's looked at.
Sorry, I was just trying to plug in your computer before it...
Before it goes.
Thanks, Leo.
So that first step about identifying the causal link of looking at the impact on the unlawful aid on the beneficiary will be a lot easier if there's a Commission decision that already looks at whether there's need for aid and whether that aid has changed the beneficiary's behaviour. In the absence of such a decision, that first step about whether there's a causal link and how the aid has influenced the beneficiary's behaviour can be assessed, for example, by looking at questions such as whether the beneficiary would have been able to sustain very low prices in the absence of the aid, and that can be analysed based on the financial accounts of the beneficiary. And then the next step is, once that's been identified, then looking at how the unlawful aid has changed the behaviour of the claimant. And in order to do this, this requires identifying the counterfactual scenario, so estimating what the claimant would have been likely to have done in the absence of the unlawful aid. Now, in terms of the tools that can be used in order to estimate the counterfactual scenario, there are a lot of parallels that can be drawn from those economic and financial tools that are now standard in the context of follow-on antitrust damages cases, and they can be sort of easily tailored to the state aid context. Now, in this situation where the claimant is arguing for lost profits, the first step is to identify, well, what would the claimant's profits have been, or indeed losses, in the absence of the unlawful aid? And that can be done using top-down approaches by trying to estimate what the claimant's level of profitability would have been in the absence of the unlawful aid, and then comparing it against the claimant's actual profits. Or it can be done sort of bottom-up, trying to estimate the main parameters of the claimant's profits in the absence of the aid, such as, for example, the level of demand that the claimant would have had, the level of prices that the claimant would have charged in the absence of the aid. And in order to do that, and it's very common in the antitrust damages context, a number of different tools can be used, and I'll just, for the interest of time, just talk about two of them. One is using comparator-based approaches, where the counterfactual scenario is estimated based on data that's observed in the same market, but in this context it would be important to look at prior to the granting or the disbursement of the unlawful aid, or alternatively, in comparable markets unaffected by the unlawful aid. So in the stylized example I gave, where the aid has led to the beneficiary and then the claimant charging low prices, the first step would have been to look at what's the level of prices the claimant would have charged in the absence of the unlawful aid. And then based on standard sort of relationships between price and demand, the claimant's level of demand can be estimated in the counterfactual scenario. And in order to do that, the prices could be looked at based on data, the prices actually charged by the claimant prior to the unlawful aid, or indeed prices charged by similar companies but operating in markets not affected by the aid. That latter approach may be more difficult to identify similar companies in markets where the aid has had no impact. It's particularly important, though, in order to ensure a robust assessment of the damages, to control for other factors that may have occurred and may have changed over the period of the unlawful aid. But that can be done through statistical techniques, econometric analysis to control for differences in, for example, the degree of competition in the market or the level of GDP, for example. So those factors can be controlled for in a similar way that would be done in the antitrust context. The other set of methods that can be used to calculate the counterfactual are financial analysis-based methods, where essentially these are using financial information about the claimant or other similar companies unaffected by the aid to estimate the counterfactual. Here, one of the common techniques is using sort of profitability analysis. So this is looking at the top-down approach to estimate the damages, based on firstly looking at what would the claimant's level of profitability have been in the absence of the aid. And that can be estimated based on looking at how profitable the claimant was prior to the granting of the unlawful aid, or based on identifying similar comparator companies that haven't been affected by the aid. And again, it's important to control for the impact of other factors that could have changed in the intervening period. Now, if the harm from the unlawful aid persists beyond the period over which the aid was dispersed, financial techniques can also be used to estimate any claims for damages for future lost profits. And those damages could essentially be estimated based on the valuation, an estimate of the claimant's valuation, in the absence of the unlawful aid, which could be based on, for example, any business plans prepared by the claimant prior to the granting of the unlawful aid to the competitor, compared with the claimant's actual valuation. Alternatively, financial-based approaches can also be used as part of the bottom-up approach, based on looking at, for example, trying to estimate the prices that the claimant would have charged in the absence of the unlawful aid, as a sort of cross-check on the comparator-based approaches. And that can be based on looking at the claimant's costs, plus an allowance for a reasonable level of profit that the claimant would have expected to earn. And that can be estimated through standard financial techniques. Once that is done, then it's relatively easy to calculate the damages as the difference between the two, the profitability in the factual and the counterfactual scenario, with adjustments potentially for interest over time. So I hope that gives a flavour of how economic financial tools that are quite standard in other contexts could be tailored to the state aid context, while in the context of state aid, the effect of the aid may be more indirect compared to, for example, an overcharge in the cartel context. The same economic and financial tools can be used and tailored to the state aid context. Thank you.
And now for the Corsica Ferries case, Charlotte.
Thank you very much. It's a pleasure to be here and to be able to talk about this case, which is one of the few examples of a successful damage claim we have on the basis of state aid. So if some of you are not familiar with this case, with the Corsica Ferries case, we have successfully advised the Corsica Ferries, which is a company operating transport service, maritime transport service between Italy, France, and Corsica. And so we successfully advised them in their damage claim against the Corsican Regional Authority, which led to our client being awarded in 2021 by the French Administrative Court around 90 million euros as compensation for competitive damage resulting from the granting of an illegal and unlawful and incompatible state aid to the historic operator, the SNCM. Maybe I'll just start with a little bit of market context because it's useful to understand then the case. The market for transport, for maritime transport between France, mainland France and Corsica was historically a monopolistic market on which only one operator company operated. It was the SNCM, and they operated on the basis of public concession contracts being funded by the local authorities. This market was progressively open to competition under the combined pressure of two things: EU law and the EU regulation of 7 December 1992, which basically opened up the market by applying the principle of freedom to provide services, maritime transport services within member states, including for cabotage. And the other, I would say, pressure to open the market was that of our client, Corsica Ferries, which began to develop a private initiative offer, beginning from Italy because of the constraints that were applied in France, and then from the 2000s onward from mainland France and the port of Toulon. So it's in this context that in 2007, the Corsican authorities, local authorities, the regional authority, granted a new concession contract to the historic operator, the SNCM, which was structured around two services. A core service, which we call the service de base, and a complementary service, which has had very distinct features. This complementary service was an additional service to the core service that had to be operated by the SNCM, so the historic operator, for passenger transport only, and only during specific periods of the year, so basically the holiday periods, so Christmas, winter holidays, autumn holidays, and the summer period. And it had to be operated with two distinct ships, which were not used for the core service, which were two passenger ships only, the Napoleon Bonaparte and the Daniele Casanova, just for the name. And this complementary service was funded directly by the local authorities through public subsidies of 35, I put it in the slide, 34 million euros per year, which amounted to a total of 220 million euros granted to the SNCM during the period in which this complementary service applied, so from 2007 to 2013. So in this context, our client, Corsica Ferries, who was entering the market and developing a private service not funded by public subsidies, filed a complaint with the European Commission against this contract and this complementary service and the aid that was granted to the SNCM. And this complaint led to a decision of the Commission of 2nd May of 2013, which found that the aid was both unlawful and incompatible because the passenger demand that was targeted by this complementary service actually could have been met by the service, the private service offered by our client Corsica Ferries, and by the core service of the concession contract. So in fact, this complementary service did not qualify as a genuine service of general economic interest, and therefore the first criterion of the Atmore case wasn't met, and so it was an unlawful and illegal and incompatible aid. Based on that decision, we advised our client to seek compensation for the competitive damage that this incompatible aid made it suffer. And we already touched base on that. So, but there were two legal routes that were open to our client to seek compensation for this competitive damage. Either go against the beneficiary of the aid, so the SNCM, but as we already said, it is much more complicated to do that. It's much more complicated to prove the causal link in particular. And the second route was to go against the public authorities and seek the liability of the Corsican authorities, and that's what we did. So we filed a preliminary request with the Corsican authorities in December 2014, asking them to pay Corsica Ferries 88 million euros in compensation. Obviously, they did not answer positively. And so we brought the case before the French administrative courts, first the administrative court of Bastia in Corsica, and then the Court of Appeal in Marseille. In Marseille, and in the end, the Marseille Court of Appeal, Administrative Court of Appeal, granted our client 86 million euros in damage plus 9 million euros in interest. So a total of 95 million euros. So just to, and I think this case is a good illustration of what has been said by my two esteemed colleagues here before me on the conditions that we have to meet to be successful in such a case. With respect to the first condition, which is the fault, here it was quite simple, I would say, not that simple, but the claim of Corsica Ferry basically derived from the Frankovic case, which we already talked about, which have long been recognized under French law and by French courts, but also and more fundamentally, more basically on general administrative principle of administrative law in France, which is to say that any illegality is a fault that engages the liability of the authority that is responsible for this decision. So basically, even under just French administrative law, we would have been able to demonstrate a fault here. But here it was even more easy, I would say, to show that there was a fault because we had a prior decision of the European Commission which already recognized that the aid was illegal and incompatible. So the second condition was the causal link, and we saw that it may be very difficult to prove the impact, the direct impact between the granting of the aid and the damage suffered by the claimant. But here again, this was rendered possible by the European Commission decision of 2013 and the specificities of this case in particular. To demonstrate that there was a direct causal link between the damage suffered by Corsica Ferries and the incompatible aid granted by the Corsican authorities, we proceeded by demonstrating on the basis of a counterfactual scenario that under normal conditions, i.e. if the Corsican authorities had not imposed and financed with public money the operation of two ferries under the complementary service, such a transport service of passengers would not, in practice, have been offered by the SNCM, the historic operator. And therefore, this service would not have competed with the transport services operated by Corsica Ferries on the same market. And here, the causal link was based primarily on the following specific features of the case. The first being that the market structure was particular because there were only basically 2 players on the market, so it's easier to demonstrate a cause and an effect. The second feature is the specific nature of the complementary service, which only concerned passenger transport during specific period of the year, and which was operated by 2 ships which were distinct and different from the one operating for the core service. So it was easy to identify really what the aid funded and which service was funded by the aid. The third feature was the 100% substitutability of Corsica Ferries offers from the port of Toulon with the offer of the complementary service, which had been recognized by the European Commission in the decision. And that was very, very useful for our case. And last but not least, the fourth specific feature here for this causal link was the fact that it was established and not really denied, actually, that the complementary service was structurally loss-making. So it wouldn't have been operated without the aid. And so once we had established these 4 features with the help of the European Commission decision, then the assessment of the competitive damage was merely a question of calculation. That is not to say that it was easy. It wasn't. Just to highlight a fact, in first instance, the administrative court granted our client Corsica Ferries 84 million euros in damage based only on a private expertise that Corsica Ferries had asked a big firm, KPMG, to do a very strong economic analysis of its loss and damage. And the court based its decision only on that. In appeal, however, the Marseille Court of Appeal ordered a judicial expertise. So we went to this process of judicial third-party expertise, which took 11 months, so not that easy, as you can see. But in the end, it allowed our client to be awarded a substantive amount of damage. And just to go, and we'll link to what Nicole said about how to assess the level of loss suffered by the plaintiff. The methodology that was used by the expert here was that of the, and I quote, economically plausible counterfactual scenario, and which can mean anything, actually, if we are honest. So, and no, but more seriously, there were several steps to determine the loss. I'll go very quickly through them, but the first one was to determine the number of passengers that was carried by the complementary service. The second one was identify the routes that could be substituted to that of the complementary service on which those passengers traveled. And again, the decision of the Commission was very useful in that because the principle of the substitutability of the routes operated by Corsica Ferries from Toulon was, it could not be put in question. So the question was more of which route on which days and a question of departure time and arrival time, but not the principle of the substitutability of the routes. The third step was to determine the transfer rate to Corsica Ferries ships of passengers that had traveled on the complementary service. And here the expert took a quite objective and factual rate because it based itself on the market shares that were observed on the market during that period of time. So we used the market share to say, okay, 72% of the passengers that traveled on the complementary service would have traveled on the Corsica Ferries ships. And the fourth step was to determine the residual capacity of Corsica Ferries ships. What number of passengers could they have absorbed from the complementary service? And here, the important thing to note for the calculation of the damage is to say that the whole counterfactual scenario was based on the idea and the fact that without the complementary service, the offer of Corsica Ferry would have been the same. So no extra boat ship operated, no change in the rotation schedule of the ships. So it would have been the same without the complementary service. The only thing that would have changed is the capacity, the occupancy rate of the ships of Corsica Ferries. And so these different steps allowed to calculate the number of passengers that would have traveled on the Corsica Ferries ships. And then to calculate the loss, what we used is we looked at what the ticket price they would have been charged and the average revenue that is generated by a passenger on a ship, and opposed to the extra cost that transporting these extra passengers would have cost to Corsica Ferries. But here again, bearing in mind that the whole calculation was based on the same offer, with no extra boat operated, no change in the schedule of the boats, and bearing in mind that this is a fixed cost industry, there were only variable costs, additional variable costs, but which are residual of the overall cost of operating a passenger a maritime transport passenger service. So in the end, this whole calculation, which took 11 months, and then again, I think 6 months before the court of Marseille, finally ended up granting our client an amount of a little bit more than 86 million euros of damage, plus interest, in 2021. And sorry, I forgot to, because I love to talk about this case. I just wanted to finish on the difficulties to have this decision enforced, because so the final decision was taken in February 2021, and obviously the regional authority refused to pay the damage that were granted to our clients, so we had to go to implement an enforcement procedure involving the prefect, so it's the representative of the state at the local level, and we obtained the payment of the principal of the damage 1 year later, and then we had the prefect had to bypass actually the local authority to have the public accountant pay on behalf of the local authority the 9 million euros of interest. That is to say that this is one of the examples of a successful claim that shows that it is possible and that you should try to do it, and that you should go to the Commission and to the national courts. One is not exclusive of the other, but that it is difficult and it is a long road. Thank you.
Thank you very much. Thank you very much for the 3 very insightful presentations. I take away, first of all, that when we will review the enforcement notice, I thought we had been comprehensive in it, but we will look at it again if we need to add some footnotes that were in the 2009 enforcement notice. And for the rest, we understand that a negative decision and other specificities help in a damages claims. But I think the toolkit also that Nicole gave should also indicate to you that it's not necessary to have a negative decision if you have the right economic toolkit to be able to provide the damages. Hmm?
Is it on?
Yeah, I think so. So I'm conscious that I'm standing between you and the coffee break, so maybe a very short Q&A session. Are there any questions, first of all? Okay. The gentleman here and the gentleman. If you can present yourself before asking the question.
Is it on? Yes, Tuomas Samper, I'm a partner at Copenhagen Economics. So the words chicken and egg have been mentioned quite a few times today. And as just established, economic tools exist to quantify damages from unlawful state aid, but there are some uncertainties, and the truth is that as practitioners, or in particular those affected by any unlawful aid, there's fairly little to draw upon by way of case practice. So my question is, to what extent this uncertainty over how to credibly quantify damages is contributing to the chicken and egg problem? And if so, how to overcome that? What could be done to provide some sort of non-binding guidance? Thank you.
Who wants to take that?
I will, maybe for the more economic part, I will let it to Nicole, but for what could be done, obviously, a practical guide on quantifying harm could be useful in the state aid field, because we have one in antitrust for 101 and 102, and judges can still take inspiration from the part 4, which is about exclusionary practices, which is the most similar, I would say, but of course, if you're not a specialized judge, being able to transpose it in the field of state aid could be complicated and could be intimidating. So yes, of course, having a practical guide for the state aid field on quantifying harm would be useful with clear examples. Once again, clear examples, it could be a bit difficult because we don't have case law, so I don't know if the Commission could be creative and imagine cases. But yes, that could be useful for the judge.
Yeah, I would agree that practical guidance would be useful. I think, as I mentioned, a number of the tools that are quite standard in follow-on antitrust cases can be used. But in the state aid context, there are differences. And in particular, I think one of the points Jack highlighted this morning, the first step in the absence of a negative decision is to quantify the amount of aid, which is not straightforward in the case, for example, of an equity injection. That involves quite complex analysis. But then also compared with, when you're quantifying the damages, compared with, say, follow-on antitrust damages, a cartel overcharge leads to a direct increase in price. In the state aid context, it could well be more indirect in terms of cross-subsidization. So there are quite a number of differences compared to the antitrust context that need to be taken into account.
Thank you. I think there was another question from the gentleman there.
Thank you. Hello. I'm Guillermo Ochoa, legal officer at Orwell. We are the Association of Private Rail Operators. I wanted to ask a question more on the Corsica case, because we are part of a preliminary ruling now in the Court of The Hague to the Court of Justice concerning concession, public service obligation in Netherlands without an ex-ante analysis, meaning that they awarded to NS a public service contract of almost all rail services in Netherlands without an ex-ante analysis of competition and the effects. And now we are dealing with this case in the Court of Justice. And also we have an infringement procedure for not complying with the regulation on land PSO. So meaning that if you don't comply, you have a state aid for the incumbent, the state-owned operator. But my main concern is how we enforce that, because in our view, member states are still, since they are the very same public transport authorities granting public service obligations, sometimes direct awards without complying with the regulation and without Article 93, how we enforce that. And then on the damages side, for us in railways, for instance, it's quite complicated, because you have public service obligations, but then you have also the equilibrium test, which when an operator has a public service obligation, they can block the entrance of new operators. How you evaluate this on damages, because it's not that you don't get the contract because they don't tender the contract according to the regulation, but also they stop new services because it's an economic equilibrium test. And my second question also would be, we had some state aid in Poland. There was a case on the subsidiary of regional services of PKP. There was a rescue of the Polish division. There were some commitments of the Polish state for that state aid concerning the market opening. How we enforce those commitments? What happens in terms of private enforcement when the commitments to a state aid are not applied or not secured, because some of our members had problems to compete in the Polish market, and in our view, they were contrary to the commitments that this Polish state accepted to have the subsidiary of PKP, which is the state-owned rail operator, to be rescued. How we enforce that? There's a room for damages when it comes to not complying with commitments with a state aid decision of the Commission, because the commitments were to guarantee market opening, and we had some decisions from the regulator saying that new commercial services were damaging the public service obligations of PKP, the incumbent, and some of our members had some issues. This can be, there is room for private enforcement on the for not complying with the commitments on a state aid decision. Sorry, maybe it was too long. It was more a reflection. Sorry.
Maybe a short answer to a long question, if you can.
Short answer. I don't know if I know how to do that in light of this question, but maybe what I would say, and I'll try to finish on that, is that there's always room for enforcement, I think. And as it was mentioned earlier, the primary face of EU state aid law is and are the national judge. So we shouldn't be afraid as lawyer, but as in what capacity we act, in whatever capacity we act, to go first to the courts, to trying to have the rule of law enforced. It's always easier when you have a decision of the Commission, but it's not necessary. And you have to be able to, when the matters are that difficult, I mean, it's not, it's obviously a difficult cases, and there's lots of questions and factors intertwined in those questions, but never always try to reach out for an economic analysis from a third-party independent third-party which has objective analysis of the case, and bring it to the judge, because a judge will not be able to assess everything. It's primarily someone who knows how law works, but not how the market functions, what are the links between the operators, how, and the economics are, I mean, it's so difficult for a judge, but go to the judge and go with economic, operational analysis that are strong, and try to objectivize as much as possible your case. I think that would be my advice.
Thanks a lot, Charlotte. I'm told that we are running a bit behind, so I want to join me in a round of applause for our speakers. Thanks a lot.
Okay, in the meantime, in the interest of time, I think it's good to start with the last panel. So this panel, after discussing the issues with the past and the present, it's a bit more forward-looking. In order to do so, we have 3 distinguished speakers. First of all, Jean-Luc Sauron. Jean-Luc is a member of the Council of State of France and is a delegate for EU affairs. Jean-Luc has a very long-standing experience as a judge, of course, but also as a state aid expert, and is also lectures in state aid and European Union law. Jean-Luc will tell us about his experience at the Council of State, advocating for state aid law application. So then we will have Mercedes Pedras, who is judge at the Court of Appeal of Madrid. She's also an expert of competition law and also of state aid law, frequently lectures and speaks in conferences about the topic. She will tell us about her experience with competition law and the distinction with the issues arising in state aid law, and whether there are any lessons learned from antitrust. And finally, Massimo Merola is managing partner of the Brussels office of Bonelli Rede. He's also a professor at the College of Europe in Bruges of State Aid Law. He has written a must-read book on remedies for state aid law. And so he has very good, is in a very good position to give us some ideas of where the Commission and the European Union could go in order to improve state aid enforcement in national courts. So without further ado, I give the floor to Jean-Luc. Thank you.
First of all, I would like to thank the official at DG COM for organizing this meeting and inviting me to attend. Allow me to introduce myself. I am a state councillor in Paris, and my main role at the Council of State is that of European law delegate. I am the point of contact for my colleagues on matters relating to EU law and the European Convention on Human Rights. In the context of EU law, I most often asked about state aid. I have been asked to present to you the best practices within the administrative jurisdiction that aim to strengthen the technical skills of French administrative magistrates in dealing with state aid cases. In 5 points. First, initial training. Each new French administrative magistrate undergoes initial training lasting approximately 6 months, alternating with periods on practical training in an administrative court. During this initial training, they study a number of EU law subjects, in particular the GDPR on state aid, and learn how to use the legal website of the Court of Justice and the European Court of Human Rights, so they can conduct research on the case law of the 2 European courts as independently as possible. Second, European case law bulletins. Every month, all administrative magistrates receive a European case law bulletin containing summaries of the main judgments handed down by the Court of Justice on the Human Rights, European Court of Human Rights, classified by court on keyword. Naturally, judgments relating to state aid feature frequently in this bulletin. Each monthly bulletin is published in the week following the end of the month. If a very important judgment is published, it is subject to a flash published the same day or the following day. There is an electronic bulletin that is sent directly to the email inbox of each administrative judge. It is the only publication of this kind in the French administration. This monthly bulletin was introduced to comply with the requirements imposed by the two European courts to disseminate their case law to national judges. Another monthly bulletin containing the main case law adopted by the Council of State is also distributed to administrative magistrates. Third, memoranda. Every 2 years, a handbook of state aid is updated and distributed to all administrative magistrates. It contains a presentation of the rules on state aid in Article 107 and 108 of the Treaty on the Functioning of the European Union. The principle of Regulation 2015-1589, the main communication and guideline published by the European Commission, the rules of SGIs and updated case law. 4. Video conferences. From time to time, video conferences are organized for administrative magistrates by the Administrative Court Training Center. These video conferences are recorded and remain available for administrative magistrates to listen to. The last one took place on 20 October 2025 and focused on recent case law on the recovery of illegal and unlawful state aid. I would like to take this opportunity to thank Bernadette Wilmot and Diana Calciu, who conducted this video conference with me. First, the Council of State's activity report. Article 39 of the French Constitution stipulates that the Council of State must be consulted on government bills, with the exception of the finance bill, the budget, and the social security financing bill. Each bill is published in the official journal of the French Republic, together with the opinion of the Council of State on that bill. Only the most important draft decrees are examined by the Council of State before publication, but the Council of State opinions and notes on decrees are only known to the ministry responsible for the decree. However, certain opinions and draft decrees, particularly those relating to state aid schemes, are published in the Council of State's annual activity report, which is read carefully by administrative magistrates and most French administration, national and local. A review of these activity reports shows the Council of State often criticizes draft state aid measures presented by the administration, particularly when it considers that prior consultation with the Commission has not been carried out in accordance with the provisions of Article 1083 of the Treaty on the Functioning of the European Union. Finally, a section of the Council of State, the Studies, Forecasting and Cooperation section, may be seized by a party or applicant who considers that a ruling of the Council of State, particularly one handed down in state aid case, has not been fully implemented. After investigation and discussion with the administration at fault, the section refers the case to the litigation section of the Council of State. The litigation section may then impose a penalty payment on the administration to ensure that it fully implements the ruling that found it had not complied with the rules on state aid. This is what happened in the famous case in France and in Europe through a primary ruling of the Council of State concerning state aid for the financing of energy wind turbines, the Association Vent de Colère case law. Conclusion, while most of the rules on case law relating to state aid are known to administrative judges, it seems to the rule on cooperation between national courts and the European Commission in state aid case provided for in Article 29 of Regulation 2015-1589 are hardly ever used by French administrative judges. Educational efforts must be continued and intensified. Thank you for your attention.
Thank you, Jean-Luc. Mercedes, you can...
Shall I use my PowerPoint?
Yes,
Even if I go very quickly?
of course. You can... So.
How do you move this? How do you
You can use this to go down, or this, whatever.
Oh my God.
You can use this
Yes.
and go down,
Ah, okay.
No?
No?
Does it
Yes.
work?
No.
Okay, you can use this.
Okay, so thank you, Leonardo. I have to say a warm thank you for inviting me, especially to him, because he has done an enormous work. I think, well, some others have been involved also, but I've been dealing with his emails all the time, so thank you so much. I want to also thank you because I have learned really a lot today. So I am wondering at the end of the day if what I'm going to say is useful at all, but well, what can I do? I mean, being the last is really a problem. So, also, Monsieur Derain, Professor Derain said something which I fully share, which is we should not be talking about public and private enforcement, but about national enforcement, because I work at an administrative law court. I must say that in Spain, administrative courts are judiciary, not like in France. We are judges, we are not administrative bodies. And I have myself dealt with several cases along the years in public state aid. Therefore, I think that his remark is very much to the point. So, I think it is very advantageous to have judges dealing with state aid cases because there is legal certainty. Judges, we have to follow the law, follow the rules. We have no discretionary powers as administrative bodies have, including the European Commission. So whenever you go to a judge, you know that there is no appreciation of discretion. No, there is always, there's going to be a judgment. You may like it or not, but a judgment will be issued. There are lots of problems, of course, some of them linked to the differences between national rules, but others have been solved already by private enforcement of antitrust law with the damages directive. As you may see here, and it has been said all along the day, state rules are complex. And not only judges, also lawyers are not familiar with the state aid. That is a fact. Of course, here you have the best of the best. All of you know whatever there is to know on state aid, but this is, a very small percentage among judges and lawyers. The consequences is fragmented litigation and very few cases in number about getting damages from state aid infringement. The procedural issues that have been identified are in general similar to those which were identified in the damages directive. Some of them have been solved thanks to the judges mainly because only Spanish judges
sent 7 preliminary rulings to the Court of Justice on the application of the damages directive. You have locus standi, of course, limitation period for bringing actions, state liability, antitrust authority as amicus curiae. Some of these things have been discussed in depth today. And, of course, the res judicata. There are other problems that were not the object of these private enforcement cases, and which I have dealt with in my own experience. For instance, who is a direct or indirect beneficiary? There was nothing of this in the antitrust case damages. Here, there is locus standi for direct, indirect, and even secondary beneficiaries. The notion of indirect advantage and the notion of undertaking are not so clear, in my opinion. And there is another aspect of the situation, at least in Spain, while the concept of locus standi is very wide in administrative courts, it is quite narrow in civil and commercial law courts. Therefore, maybe this could bring people to go to one type of court or the other. The res judicata aspect of the thing is the res judicata doctrine of the Court of Justice applicable also in this type of cases? What are the consequences of the Lucchini and other judgments of the Court of Justice while bringing state aid claims? I have here a case which is one of the ones we have dealt with, and which seems very simple, and it is quite common. It is a public contract where the claimant said that there was an state aid, so the contract should be declared void by my court. And we declared the contract void because the European Commission, between the beginning and the end of the case, declared this action by the Spanish government and state aid. It was a case of the maritime transport to the Balearic and Canary Islands. It was essential to the well-being of the country that somebody was dealing with this transportation, but it was very, very difficult. So the Spanish government gave a huge amount of money to the company, which finally got the contract. That was a state aid, but the Commission said, yes, it's a state aid, but it is a public interest situation, and therefore we didn't allow damages, because if the European Commission says that this state aid was of necessity, was necessary, how could we allow or grant damages? So some questions in a situation like this one, and we have had others. How to establish that the claimant would have been awarded the contract, because they said if Transmediterranea was not awarded the contract, I would have been the one. The fact that the company did not get the contract in itself produces damages, I wonder. How do you prove in a situation like that one the consequences of not being awarded the contract? And last but not least, if damages were awarded in this type of public tenders or public contracts, would the damages constitute a state aid? You know about the doubts we have had on the judgments being possible state aid. There are also other issues. I am running out of time. Different limitation period in public and private enforcement. Should this also be essential to defining the person or firm to go to the administrative courts or private courts? And very interesting also, we in our administrative law courts, we establish a limit to the judicial costs, and a very, very low limit, I must say. So it is very interesting to go to our courts because the expenses are going to be quite low, which is not something that the private law courts used to do. So unfortunately, I am always thinking about problems, not about solutions, but as was the case with damages directive, thinking the problems leads to bright minds like those who are here today thinking of solutions. Thank you very much.
Thank you very much, Mercedes. Now, Massimo, the floor is yours. Let me just move to your slides.
Okay, thank you very much. Yeah. Good afternoon, ladies and gentlemen, distinguished members of the DG Comp and Legal Service, dear colleagues. It's a pleasure for me to participate in this reality check event. This is the scope of the purpose of my intervention. As agreed with the organizers, after many detailed and thoughtful interventions, which helped to take stock of the current situation, including the weaknesses of the present system, I would like to offer some forward-looking suggestions, a forward-looking view from the perspective of possible developments and reforms. A quick flashback is necessary, though, to ensure my proposals are clearly understood. There are essentially two types of tasks entrusted to national courts. First, the assessment of whether a measure qualifies as a state aid and whether the state aid is existing or new. And second, which are the remedies that can be imposed in case of unlawful aid. Now, if we look at the initiatives taken by the Commission in many years, in the last years, these have been taken mainly to strengthen private enforcement under with three instruments: the notice on the notion of aid, which remain a key reference, the cooperation tools in Article 29 of the procedural regulation, and the number of training activities for national judges. These are, of course, powerful tools, although I am not a fan, I must say, of interpretative communications, such as the notice. I think the court's case law remains the decisive complement to the Commission's initiatives. While the Commission provides operational guidance, the court supplies the overarching theoretical architecture, conceptual architecture. Furthermore, the notice, or notices in general, often become obsolete. And indeed, the 2016 notice had already become obsolete in December of the same year, following landmark judgments adopted in December 2016, such as World Duty Free, Lubeck, Aer Lingus, and others. It is true that in the field of state aid, the court has not always delivered. Many judgments in the past, since the 90s, fell short of providing the guidance that stakeholders and the Commission expected. We would need another conference to go through these judgments, but I think it is sufficient to say that for many years, case law developments have been fragmented, provided only very narrow indications adapted to the specific cases, and sometimes have led to increasing confusion, lacking a holistic view of the subject matter. However, there are signals of a significant reversal of this trend, as recent Grand Chamber case law shows a promising efforts towards a more structured and systematic guidance. And I have taken here two examples, President Miasta Mielka case of April this year and SSS of a couple of years ago, 2023. In these two judgments, indeed, the court supplies that architecture, that conceptual architecture that we are all looking for in the issues concerning the notion of aid. I am particularly enthusiastic about the first one because it goes very close to the notion of virtual general measures that I had proposed to adopt in an article written in the same year, 2016. And in SSS, the Grand Chamber clarified how to apply the notion of state resources and imputability in the context of energy market regulations. And in that judgment as well, the Grand Chamber looked at the full picture, not just the specific case pending before it. If this judicial trend continues, it can offer national judges a clearer and more consistent interpretative environment. However, all the instruments in place, even the court's case law, focus mainly on the first task entrusted to national courts and not so much on the second one, which is the selection and implementation of appropriate remedies in cases of unlawful aid. According to the court's settled case law, and particularly the Sfei judgment, national courts must draw all appropriate consequences from breaches of state aid procedural rules in accordance with national law. So apparently, in principle, they enjoy wide discretion in choosing the most effective remedies. In practice, however, the discretion is significantly weakened by the absence of procedural provisions in many member states, but also the lack of a sufficiently flexible model in EU public enforcement, and the strong focus of public enforcement on recovery and recovery of the nominal amount of the aid. Probably this choice is dictated by administrative efficiency reasons, but nobody understands how it works in case of indirect aid, and should a different approach be taken for direct and indirect aid respectively, nobody understands what the theoretical basis for this difference would be. So the risk is either a mere replication at national level of recovery focused on remedies focused on recovery of the nominal amount, or the emergence of fragmented and inconsistent remedial systems across the Union. Now, to delve deeper into this, we can look at the threefold role that private enforcement is expected to fulfill: preventive, complementary, and supplementary. The preventive role is essential to prevent a beneficiary from enjoying unlawful advantages during lengthy administrative or judicial proceedings. The preventive role is probably the less problematic, as case law offers clear guidance. However, since preliminary references to the court are not possible at the interim stage, enhanced cooperation with the Commission becomes crucial, and one possible improvement would be the establishment of a fast-track channel for urgent requests by national courts in precautionary proceedings. As to the complementary role of national courts, the complementary role is exercised in follow-on actions after the adoption of a Commission decision. In such cases, national courts are typically required toward the repayment of interest for the unlawful period of enjoyment of the aid, or to award damages that go beyond the mere recovery. The main challenge here lies, as it has been explained, in the proof of the causal link. However, there is much unsaid in both case law of the Commission and both the case law and the Commission practice on this specific point, on the complementarity. A potentially very significant development in this area is in the hands of the Commission. By reasoning more comprehensively its decisions on issues such as the actual effects of the aid, the link between the compatibility assessment and the remedies, and the complicity of beneficiaries, the Commission can significantly facilitate the role of national courts and even pave the way for the recognition of the beneficiaries' liability under national law. So, in other words, judicial efficiency and legal certainty could be improved if a Commission decision systematically included a section on expected follow-up of its decision and possible liability of the beneficiaries. Now, the supplementary role is exercised through standalone actions, not follow-on, but standalone actions before national courts without a Commission decision. This is the most important area, as national courts must themselves remedy distortion of competition caused by the unlawful aid. And it is also the area where the problems that we all witness are more acute, as national courts do not have the guidance of a Commission decision. In the absence of immediate legislative action, I think that two developments would be particularly desirable. First, the principle of effectiveness can be strengthened so as to encourage national legislators to introduce specific procedural basis for state aid-related actions. And second, it could be clearly established that the procedural autonomy implies not only freedom to design procedural rules under national law, but also a duty to apply remedies that are capable of restoring the competitive situation before the granting of the aid. So this is part of the autonomy, it's part of the procedural autonomy. So now, while short and medium terms improvement through soft law instruments and cooperation mechanisms are essential, they are not sufficient to remedy the shortcomings, the structural shortcomings of the current system. A comprehensive reform requires legislative intervention on two fronts, public and private intervention, in order to foster a reciprocal fertilization of the two areas and a true breakthrough development. On the public enforcement side, I don't spend any time because it is not the subject of this event, but I simply say that a modification of Article 16 of the procedural regulation would be welcome to avoid the present situation of recovery being either over enforcement or under enforcement. So the recovery of the nominal amount leads to under or over enforcement depending on the case. The Commission should be granted a broader discretionary power to select on a case-by-case basis the most appropriate and less intrusive remedy. Such a reform, and I don't spend more time on this, would be beneficial also in the field of private enforcement, by fostering a complementarity between public and private remedies rather than the current parallelism centered on recovery. The second necessary legislative step would be the adoption of a harmonization directive on state aid private enforcement. A directive could establish minimum requirements, minimum common standards on standing, admissibility, access to evidence, causation, and quantification of damages. Such a framework would facilitate actions for damages, but not only action for damages, whatever kind of action is appropriate under national law. And it would ensure that the right of compensation is neither illusory or excessively difficult to exercise. So fostering the principle of effectiveness while still respecting national procedural autonomy. In conclusion, a modern and effective system of state aid control cannot rely exclusively on Commission action. Private enforcement, so enforcement promoted by private parties before national courts, must become a true second pillar of the system of enforcement. In the short term, significant improvements can be achieved through targeted developments in the Commission practice, as I explained, in particular with regard to follow-on actions, and through soft law. Yet, soft law and practice alone cannot close the structural gaps. Real progress requires strong political commitment leading to legislative reform. Only through such reforms can public and private enforcement become genuinely complementary and mutually reinforcing, and would be consistent across the field of public competition law. Thank you.
Thank you very much, Massimo. I would say, since we are running behind schedule, I would invite the audience for a couple of quick questions.
Just a quick one. At the stage of establishing...
Excuse, just 1 second. Sorry, Jean-Luc Soron he must leave us because he must catch a train.
Well, as I was about to say, at the stage of establishing state aid, I can imagine describing a wrong decision as over-enforcement or under-enforcement, even though it could be a bit of a stretch of the term. But at the stage of recovery, when we already know that there is state aid and it is illegal, and the rule is that illegal state aid must be recovered, I'm not quite sure what you meant by over-enforcement and under-enforcement.
Massimo, maybe you want, I think it's a question for you.
Yes, I'm not sure. I'm not sure I understand very well. What you say is that once it has been established that there is unlawful aid, then what?
Then there is no further room for talking about over or under enforcement. There's just enforcement. It has to be
Yeah, but enforcement how? With the recovery of the nominal amount. And that can be under or over enforcement, depending the situation. If you recover the nominal amount, I mean, perhaps you have not restored the situation existing before the aid was granted, so you still need national courts to complete the work, or you do too much sometimes because there is, I mean, the market has already evolved and the anti-competitive effect of the aid has disappeared meanwhile. So what?
I think Massimo is challenging the case law, is proposing a way forward that is different from the status quo.
So to say that recovery of the nominal amount is the natural consequence of the unlawfulness of the aid, I mean, fine, it means nothing from the competitive point of view. I mean, I'm very sorry, but from the point of view of restoring the competitive situation pre-existing to the granting of the aid, this is meaningless.
Leo Flynn, Legal Service, European Commission. Two comments. First, I agree with Professor Merila that the restoration of the status quo ante is a quest that we undertake basically more in hope than expectation. Because, let's face it, the treaty system is designed on there never being unlawful aid because it rests on a system of prior notification. So, from that point of view, anything that we do in all of this is going to be a very crude and approximative attempt to get back to where we should never have departed from. And so from that point of view, one can critique the various approaches, but I don't think that it's enough to say that we should try to completely rebuild the world as it would have been without the aid, because simply that's never going to happen. That's something that cannot be apprehended. The world is imperfect. There are too many variables which are involved. And so from that point of view, we know that the court has, to some extent, taken a Solomonic approach of saying that recovery of the nominal, we consider gives rise, with appropriate interest, we consider it gives rise to a restoration of the status quo ante. That was a comment. The second was to ask a question. Should the Commission, as a public institution who has as a role ensuring that it focuses on questions of compatibility, use its resources in order to facilitate the claims of private operators rather than the general interest? And so seen from that point of view, if I pose that question to the panel, I'm not sure, let me rephrase, I would be surprised if the Commission should, for example, engage in market studies to show exactly how there's been a distortion of competition, rather than simply reflecting the, for example, Alzetta case law on saying that when there has been an advantage provided in a selective manner in relation to an activity for which cross-border trade is possible, there is distortion of competition. The whole element that would make it easier to bring follow-on claims, I don't think should be a central consideration, and also I don't think that it would be very wise on the part of the Commission to go down that route, because it might end up in a situation where a much higher standard was demanded of it, even though it's not legally indispensable.
Well, on your first point, I agree that in some cases, such as tax ruling cases, taking the nominal amount of the aid is probably the only possibility you have to make a reasonable calculation of what the recovery should be. But this is not the solution to the problem. It remains that in many other cases of direct or indirect aids, in case of sale of assets, sale of companies, and so on and so forth, the recovery of the nominal amount is, meaningless in terms of restoration of competition. And on your second point, Leo, I think that, I don't remember the second point. Second point
right negative decisions, right compatibility decisions, or right decisions establishing the existence of aid based on a detailed market analysis, so that in the event that there's an unlawful aid measure, it is easier for competitors or others to obtain damages against the public authorities, because the competition dynamics have been examined.
But you know very well that in the large majority of cases, there is no link in the Commission decision between the compatibility assessment and the recovery. I mean, nothing explains what is this link in the Commission's decision. There is the compatibility assessment, full stop, and then there is the examination of whether recovery is compatible with general principle of EU law, but there is no link between the two. On your point, the Commission is wise or is not wise to do something more in the decisions that you raised before. I mean, you organized a conference to search for solutions to the problem of private enforcement. I'm trying to offer some solutions. I mean,
Massimo,
I
sorry.
understand that it can be burdensome.
Sorry, just I think there was a question over there. I haven't seen any. This will be the last one, and then we'll close. Just want to reassure you.
It was a sort of a comment on the whole over and under enforcement issue, and on the notion that recovery. I mean, there's a distinction in state aid between.
State your name.
Oh, sorry, Simon Yarak from Auxerre Consulting. So coming from an economist, there's the distinction between the economic advantage, which is the aid, and then the benefits, the economic benefits derived from the advantage. And recovery removes the advantage, but not the benefits. And even on the advantage part, there can be over or under enforcement. If you have a loan of 10 million with a cheap interest rate, if you recover the whole loan, that's arguably over enforcement because only the cheap interest rate was the advantage. On the question of the economic benefits, then it's a wider question. I'm not sure, I don't know as an economist whether the legal framework requires those benefits to be restored as well to the status quo ante. And then perhaps one small comment on the question of negative analysis of the negative effects in decisions. I don't know in a weird roundabout way if we can expect benefits from the FSR here, because that's an area where the Commission will have to articulate negative effects, how behaviors are affected and how that affects competitors. And hopefully with a bit more practice, we'll be able to sort of link that back to the state aid context as well, perhaps.
Thank you very much for supporting me with your comments. On the first one, I entirely agree. On the second one, I have written something, the third part of the book that I published is exactly on what you said. So the model that foreign subsidies regulation can offer for the reform of remedies in state aid law. So thank you for that as well.
Thank you very much. I think with that, we can close the panel and the conference, unless, Mercedes, you have any comments. Thank you very much for participating in this conference. It was a very useful exercise for us, a lot of food for thought, and I hope that it was interesting for you too. Just two information. One is that the recordings and the slides will be available through our website shortly after the conference. And the second point is that for those who are going to the cocktail afterwards, there will be a bus waiting in front of the building. Thank you very much. Bye-bye.